1850. Final hearing is on 15. So we need a date before that.
What?
We have made a writ appeal for 1850. The final hearing is on 15.
You pass on the memo.
Yes,
It will appear. But that's all. Why you are exhausting your energy?
Item 1.
Give me.
After the head note, with a lot of repetition also. With a lot of repetition also. I have to recast my entire records. Because
What has happened?
Here
it's old matter.
Old matter.
What is there? Is it still alive?
It is not, because it has
It is state civil supply corporation. It is state civil supply
State
corporation.
civil supplies corporation.
What? This is only 5.
So this is a matter which in the old 256(2) is referred to this honorable court for your lordship's answer to
SJC.
certain queries.
Now the section has undergone a sea change.
The section has now become 260A. There's 256 and 2.
That means it has gone.
No, it is still alive because these matters. So there's a
I am asking you that this section, which is the subject matter here, has it undergone
This subject matter is only for enable the tribunal to make a reference to this court on my application to the tribunal on a substantial question of law. So that I made an application at 256(1). So since that,
so only to ascertain whether it involves a substantial question of law?
The substantial question of law has already been framed by the tribunal. Under 256(2), your lordship have to answer it and send it back to the tribunal.
Why it remained pending for such a long time, more than 20 years, sir?
This is having a cumulative.
And this is the total file which we have.
We do not have the entire brief also.
The records have to come also. The assessment, the first appeal, and the tribunal.
Is it still traceable or available?
I think about
The income tax department. Any person from
income tax.
today's tax day, they are supposed to be here. Just inform.
I just reconstitute.
Just inform.
Mr. Kaur, the senior advocate appearing for the commissioner's order has gone there in the tribunal.
I don't know.
So the tribunal will send all the record. That's all.
We have to only decide
Only
the
ask
question of law.
question.
Only permit me.
Yes.
Order number 8. 3 weeks further time is allowed to take to file paper books. हाँ तक पकड़ाओ नहीं कर
Not that one. So
सारों पकड़ाओ नहीं brief नहीं brief हासिल से collect करें.
Record from the lordships.
what you will reconstitute? Give him.
Do not
record.
serve.
Give him a record. You constitute. Reconstitute. We are happy.
It's only the. It's only.
Please look at it. Both of you look at it. What you will reconstitute? Reconstitute. We will be happy if you reconstitute.
Sorry, I stand corrected. The lordship will call for the records. The reference below.
It's all better.
Nothing is there. Reference is also not there.
It is also doubtful that whether the record is available in the
No,
That is what I say. Is it traceable or
It will be better if he files a
only says 256(1)? That's all.
This
What is the point of reference is not here.
The statement has not come.
That is what I'm saying.
Lordship, you just record the RA number and the ITAC appeal number.
Just give a RA number.
Item number
If you
2.
can get the certified copy of the entire brief, then it's.
You are.
But whether Civil Supply Corporation will be in a
Eh?
position to.
Who is appearing for the Commissioner of IT?
Okay.
Who is appearing?
Now, Mr. Kindly ask Mr. Kedia to be here.
I'll
He is, I think,
not present
income
now.
tax. He is now in the panel of income tax.
Well, he's a junior counsel. I'll inform Mr. Mahanti as well as Mr. Kudi.
So that's
Yes, call the next one.
Item number 2.
What is this?
This is also the same.
Let us see what file.
The question of law must have been framed. There is a defect of this quarter. Annexes.
These are the two references in this case. Very interesting. First reference is whether the judgment of the Income Tax Appellate Tribunal Cuttack bench confirming the order of the Commissioner of Income Tax Odisha under section 263 of the IT is correct in law or not? Is this a point of reference? Whether under second, I can understand whether all the expenses of the SSC are not verifiable, and on the basis of such finding, the order has come without verifying all the expenses.
Your Lordship, your Lordship, one type of order. Chief Justice, then Chief Justice Murli, your Lordship, is passing this type of order in these cases. Your Lordship, because in 20 years, 25 years, no action has been taken, no notice has been issued. So, keeping open the question of law, your Lordship, to be disposed. Because many petitions were pending at that time. Your Lordship, so
What to do, sir?
Passed. Even non-appearance of both sides, your Lordship, sometimes.
This must be known to Mr. P.K. Jana.
Brother,
This was filed by.
just imagine what answer to these two questions will be given. Read. This order is not under challenge. Just imagine the order is not under challenge. If you want to take a dissenting view,
SJC, I think, is not now there.
No,
Like
not.
Odisha Sales Tax Act that has converted to revision. Revisions.
Income tax appeal under.
No, the provision has gone under change. This section 24 of the Odisha Sales Tax Act.
so why we
Similarly,
keep this matter? Because this now the provision has gone. Now nothing is coming out. What is required?
Provisions might have undergone a change.
So
They may be
we
approaching.
can always take into note or a consideration the change in law.
No, this particular provision, my lord, is only for filing of an appeal or referring a matter to your lordship's court. That has nothing to do with it.
Probably you could not understand. Now, what is our query is that at that point of time, there was a provision where the reference to answer a particular point can be made to the High Court. And keeping that particular appeal, second appeal or appeal before the tribunal pending.
No.
No.
After this.
After this.
Thereafter, reference application is
Okay.
filed.
Okay. Now the question is that the matter has already been decided by the tribunal. Only the reference is to be made. By this time, this particular provision has undergone a sea change. Now, any judgment which was based upon the earlier notions, now by virtue of a change in law, has now become really an academic.
Great respect means the question of law does not become academic, but
Why?
only the provision in which I'll be approaching your court.
No. Even
Even
a question, the question will become an academic because of the reasons that
Because otherwise,
there may be several changes that has taken place in the meantime.
otherwise, my lord,
Just a minute.
No. As this reference I find, this reference was that while allowing this particular expenses, whether all the documents are required to be verified. This is what the reference is.
Mr. Kara,
That is what is the reference.
Mr. Kara, like OST Act, that SJC provisions got changed into revision. So there is a saving clause there. Whatever cases of reference application under SJC was pending prior to amendment. So they are converted to tax revision. And High Court is to whatever pending in High Court, they were converted to TREV. Isn't it? So similar aspect is carried out in income tax or not? That is what Mr. Jana, you can. Mr. Jana, you can also assist. Sir, income tax appeal. So that was converted there.
I understand. If it is converted into a tax appeal, then the substantial question of law has to be framed. That is
not done.
But now,
Now.
Otherwise, my lord,
No, that is why what Mr. Misra says. Similarly, we have been passing that keeping the question of law open. Maybe very pecuniary limits may be very negligible or insignificant now.
now, so far as the quantum of the amount is concerned, now the policy has also come up to certain pecuniary limit.
be binding on the
They will
That
not-
is for the
they will not-
department.
That's the department.
That is for the department.
Public to correction, my lords, may I just humbly pray your lordship may kindly peruse section 216. This, my lord, this has come, my lord, with effect
Income Tax Act is here.
I've borrowed a lordship.
Oh.
260, my lord.
260.
260.
We'll share it. You keep it with you.
256, it begins, my lord, as reference to the High Court. The lordship would see the left-hand side, my lord. 256, statement to the High Court. Then 256, your lordship has seen, my lord. Then, my lord, the lordship would see the statement of the case to the Supreme Court in certain cases. And decision of the High Court, the Supreme Court on the case.
260 you are reading.
260, 260.
260.
The High Court or the Supreme Court upon hearing any such case shall decide the question of law raised therein and shall deliver its judgment thereon containing the grounds on which such decision was founded, and a copy of the judgment shall be sent under the seal of the court and the signature of the
That
registrar.
is what, sir,
to the-
because my common understanding of the law was that in all the cases of a reference, it is only the point of reference which is to be decided by the court or a High Court or a Supreme Court. The matter would remain pending before the Income Tax Appellate Tribunal. so that the moment the answer to a reference is given, then this appeal will be decided. That appeal
No,
will be
the
decided on the
reference will be
basis of that.
No, the reference will be decided. And below,
Sir,
sorry.
my expressions are very
No,
bad.
I'm sorry.
Please consider this. What I am saying is the same thing.
Man,
I am telling you, there is a distinction. Then I am telling you, then you should know there is a distinction. In case of a writ, in case of the first appeal, and in case of a second appeal, once there is a reference to a larger bench, then in that case, the larger bench will not dispose of the main matter. It will simply give an answer to the reference and will send it back to the respective court who send it for reference. And on the basis of that answer to the reference, the main matter will be decided on merit.
Yes.
Exception is the revisional application under section 115. If any reference under the revisional application is made, then it is the lock, stock and barrel, the entire revisional application is sent to the larger bench. And the larger bench, upon answering the reference, will dispose of also the revisional application. So this is what is the only thing. Here what I find is that the main matter would remain pending before the appellate tribunal. Once he sends the matter to the High Court or a Supreme Court to answer a particular point or a reference, point means a reference, we call it a reference. Then the moment it is answered, it will be communicated to the IT, and ITAT on the basis of that will dispose of the matter on merit. So it will remain pending. That's why I asked whether the matter is pending there. Then he said, my brother's contention was that it is not the ITAT who is keeping the matter pending. He is disposed of the matter. Then subsequently an application is made for answering a reference, and on that basis, if he refers, so there is no pending matter in that. It is only the question of law which has to be answered.
After that it
Our
goes back,
disposal.
then they will again hear it and pass the effective order in appeal. I think
In a disposal of appeal.
Yes,
Very interesting.
I think that is
Once the matter is disposed of, he becomes functus official, except to the very limited extent, revision or review or whatever.
It's your lordship may say it's like a review application, the reference application for the sales tax matter.
for effective order, after passing of
So then
order and
he
reference.
will really decide the revision or the review. That is what is the difference. I understand.
now after revision provision has come into
So now
statute,
what is to be done? He can decide.
Unless
Let him-
they have already decided the matter. Now on my application under 256(1), the matter is referred.
I understand. On a particular proposition of law, the difficulty in the second matter which I find,
I'm sorry.
in the difficulty in the second matter was that there is already a judgment of the ITAT Cuttack, which says that all the expenses which a SSC claimed is not verifiable. Then the question was that whether it is verifiable or not verifiable. Assessing officer will go by the ipsi dixit of what the SSC has shown and expenses without any corroborating document, without any verification, or a verification should be done and then allowed. This is the answer. Answer is simple. Somebody claims an exemption or somebody claims the deductions. Will he not prove? Will he not show? Under the common law, just tell me. He said, I have purchased the computer for my office establishment. I'm entitled to these expenses.
The onus is on him, Lord.
So then he will prove, he will show the document. And this is the reference which has come.
I think Mr. P.K. Jana was dealing at that time.
Look at it, this is what, I'm really surprised.
That was your erstwhile office.
Give,
That's why.
give it to him. Look at the 2 point of reference. Look at it. Please show it to him also.
He hails from that office.
Ah, the point of reference, 1 or 2. Look at 2, very interesting.
Whether on the facts and circumstances of the case, the learned tribunal has material to state and all the expenses of the SEC were not verified. And on the basis of such findings, the ultimate conclusion having been drawn, the order. Maybe this is a question where
Master, very interesting. Answer is very clear.
maybe Lord.
And tribunal's order is not before us.
No,
It's not there. I was not available, not before. I'm wrong. It's not available.
The only
That is
thing
the only brief
which
which
I
we have.
perceived whether was that since ITAT is a coordinate one, if you want to depart from that view, then there's a problem. So he has simply referred the matter. If the higher forum has set aside that order or say that this order is not a good law, then matter it's.
Maybe, my lord, there are certain materials before on records which has been ignored by the tribunal. So that also becomes a question of law. where
Under
whether it's
which be that record we cannot.
That is not there.
we can't presume, my lord, from the question.
That is what I'm saying. The reference as it stands.
Apart from that, this harm is no more in existence.
We also do not know whether the SSC is anymore.
No, that's what he's saying because he hails from that office. He says that the form is not there. No.
I am going further. I say whether SSC is there
Is there?
is a matter of a long precedence.
It's already dissolved.
That is what I am also thinking. The firm is not there. The SSC may not be there.
Many cases are there, so we can.
Yes.
We will say that since many years nothing
First matter also the same thing,
happened.
Mr. Kaur. Same treatment.
Not to leave the question open.
That is what I'm saying.
This is the type of order.
The leave. That is what you look at it. 4-line order.
It'd be also a Herculean task for me to go to the tribunal. and-
That's true. That's the true. Please look at it.
Now, whether Civil Supply Corporation now will press for that seriously or not, I don't know.
We'll say none appears.
Only one minute rider subject to. I'm talking about the first.
देखिए,
The making a submission is the first case.
ये कागज तो दो. हाँ.
So I've said that consequently leaving the questions of law sought to be urged in this revision petition open. This has to be changed in the first case.
No, this is OST.
This is tax.
This is OST.
But so far as the my case is concerned, it's a reference under 256(1). Your lordship may say that the question of law is left open to be and
Considered in an appropriate case.
and liberty may not to raise that issue if at all it arises.
But he is always there. If it is kept open, liberty is automatic.
We have not decided anything. No?
Second.
So naturally it is kept
Mr.
open.
Kaur, you are a seasoned and a veteran.
I still consider myself to be a learner.
No, sir.
Much to be-
You are a veteran in the provision. From a junior, I can understand.
Your lordship,
Once it is kept open, that means it has not been decided.
your lordship may pass the same model.
Yes.
Item number 3.
So far as number 1 is concerned also.
1, 2, save. 2 will be none appears. for the.
Item three.
This has gone to Supreme Court. Thereafter, Supreme Court directed to frame another question to add this, isn't it?
In
So that
fact,
is not the-
183, what order I have submitted, that order is one of this case. Why, well, the department has filed two revision,
Same treatment.
183, 184. So if your lordship permit, I'll say that God,
Adding one another question.
whether bandage and gauze are.
Yes, for the fourth.
Item number 4.
Item number 4, your lordship, the question of law has been framed by this honorable court on dated 26/8/2000. Your lordship may kindly look into the order on 26 August 2000. The question of law has been framed. Your lordship, the amount, page 11, your lordship, I don't have the brief, I have tables from here. Your lordship, your lordship, I have
Fiscal tribunal is justified to allow indulgence.
Yeah.
Because the material supplied by the contracting in case of our administrative dealer.
I may not place this case. Your lordship may kindly, your lordship, kindly look into the tagged matter 208/2001. 208/2001.
Yes.
The order dated 5/8/2009.
208.
No, it was
208.
order dated.
Order dated 5 August, 5th August 2009. There is an order.
In terms of our disposed of.
Your lordship, no recent data. The question, but that unfortunately that order is also not with me. Another part, the quantum of the appeal is 5,000. The quantum of the appeal is 8,827. Government has issued a notification. Your lordship also not to pursue so far as until 25,000. So in all things, let it dispose of.
In all set and done.
No, tax interest.
Filing.
Again, no, filing. Administrative commissioner has.
No, will not proceed or will also filing.
As your lordship, I leave it to your lordship. Pursuant to that order, your lordship may dispose of.
That is what we think.
Your lordship. Only I don't have that order.
There are one is not to fight and another is not to pursue. Also, so this pursue.
In fact, your lordship may dispose of by
this order.
that one.
Brother. Same.
Because same question of law I have already perused from here.
This is applicable to other tax cases.
Your
Yes.
Pending tax cases.
Brother.
So it's not be, may not be, this notification may not be applicable.
2009.
My lord,
208.
Yes, sir.
my lord, I beg to pardon, my lord. The list of the Honorable Justice K.R. Mapaka did not function. Item 21, my lord. I can taken up today, my lord.
What is the urgency?
Urgency that, my lord, partition should be pending between the brothers. Now the land acquisition officer is going to disperse the compensation.
What partition suit is pending? Have you obtained any kind of a stay?
No, my lord.
So have you made any reference under
Yes.
section 33 or
My lord,
under the Act 1 or section 18?
my lord, the fact remains that, my lord, the land acquisition officer in the earlier order.
You are going to take advantage of something else. That partition suit is pending.
My lord,
Then what is the application you have filed?
I file objection that till the pursuant decided, let the compensation be deposited, whatever the deposited in the bank account should not be dispersed till the disposal of partition suit.
What partition suit is what state?
Partition suit notice is not sufficient, my lord.
I am asking you, this appeal is filed against the preliminary degree or final degree?
My lord, partition suit is at the stage of admission notice is issued. And
Sir, you cannot file a partition suit in the High Court.
no, my lord, partition suit pending in civil court.
Right? What you are coming here, you have
I
come here.
am challenging the order passed to the land acquisition officer.
Land acquisition officer say partition suit, so I was really, is there any injunction order?
No, my lord, no. Because,
What is
my
the
lord,
urgency?
what happened, my lord? the land acquisition.
You could have raised an objection there for disbursement.
Yes,
Then the point of reference, the land acquisition officer will refer the matter. What is the urgency?
because my lord,
There are two aspects. One is entitlement under section 18 of the LA
yes.
Act 1 of 1894. Another is 33 when apportionment is disputed. Then go there.
My lord, what happened in this case? The land acquisition officer posted the matter to 30th of December. On so motto, again taken over the matter on 31st 10 and passed the order for disbursement. Without any advance application, so motto taken over the matter and
Listed at 2 p.m. Let us.
Yes, ma'am. Serial number, let us provide this. Item number 5.
One Ranjan and the petitioners, the joint license holder of exclusive privilege for manufacturing and to operate the sale of West liquor shop. And subsequently, due to illness of the Ranjan Pradhan, the opposite party number 4 was inducted as a business partner.
Subsequent.
Yes, my lord. That's the opposite number 4.
The erstwhile partner or he is an added partner.
Yes, the added. After taking my lord, he did not.
Have you reconstituted the partnership?
Yes, I have supplied. I have Annex 3. I have with the deed of partnership submitted before the collector. And also, after getting this, the opposite party number 4 now allow me to operate that shop. In this respect, I have filed.
Opposite party number 4
Yes,
is a
subsequent inductor say.
subsequent.
Yes,
So,
subsequently he has inducted as a business partner. But after getting this, after supply of the deed of partnership before the collector, he did not allow me to operate the shop. I have made
private dispute.
yes, no, but what happened, my lord?
And it's a private dispute. You go there and settle the dispute,
I am going to that.
against the partner.
I am going to that one, my lord. As I have made complaint before collector. My lord, as per section 24 of the Bihar and Orissa Excise Act, has to take in action. Till today, I have made the complaint.
Only
That complaint may be
the suspension of the license or cancellation.
Yes.
Only thing is they cannot alter the partnership, the constitution without the permission of the other.
Yes.
Can they do it?
Your permission was granted.
It was granted.
Yes,
Oh, then
that's the time is
it is a private dispute.
base 9
Then
paragraph
as
10.
section, my
Base 9
submission
paragraph 10.
of
That's the time you have a
my submission, I am not going to
Just
that.
1 minute. Yes,
Base 9.
violating the terms. That's all allegation against him.
Yes,
And he is referring a particular
that I have opened instruction.
provision of law. Of the excise act.
We have it. Exclusive privilege under section 20 shall not do this. Or also the same. Unless he is express.
So what is this 22, sir?
Because of the collector, that deed of agreement I have submitted.
No, sir, that was already granted to you,
Yes.
the permission. Then now, after the permission, if there is any dispute amongst the partners, then it is really in the nature of a private dispute. You go and settle it.
Uh,
How the commissioner will do?
Only grievance before lordship, I know limited grievance before
And
lordship.
22 does not talk about any action to be taken.
What we have to implement regarding the deed of agreement. that-
You have already, the instruction
My-
is
my-
that everything was intimated. Ultimately, the license was
Yes.
renewed or granted in the name of a newly constituted partnership for, which is valid till 26.
Madam, limited grievance before lordship, I know. My complaint pending for the collector, that may be resolved.
I'm a bad person. That is up to them. No.
That is some other so that
Sir, we cannot convert the civil disputes into a constitutional disputes and then make a fresh cause of action for another rate petition. Sorry, I'm the last person. It's a purely a civil dispute. You can go and take a recourse to whatever is wrong. No, sir.
that instruction they kindly supply to me, that I can take instruction.
Instruction is nothing. He says that in terms of section 22, you made an application.
I have
The basis of
made
a duly
application.
constituted, which you are not denying.
Yes.
They say the commissioner, after taking into consideration, allowed it. Ultimately, the license was issued in the name of a newly constituted firm. And thereafter, my liability goes because the license is still valid. That's all. That's the instruction. And 22 does not contemplate any adjudication, nor it contemplates any consequences or the penalty to be imposed. That's it.
Your also may direct so that I
we told many of the additional government advocates that please be denied.
No. Here, against the show cause notice, I have approached. Lordships have directed that
What you have done?
on my prayer that I'll file reply, Lordship disposed of. But there is a time limit was there by 30th. Since the petitioner was suffering from ill and
You
numbness,
extend the time.
that is, I have already filed. Reply. That is not taken up because Lordship's order is there that 30th is to file. That is the only cause.
That I have obtained, sir.
Only that date may be extended. I have filed on 3rd November. Already filed. And it has been accepted, but that is not taken up because of this Lordship's direction is that by 30th.
Where is the direction?
Lordship at page 20. Paragraph 4.
20. Oh.
30th August, Lordship.
We extended till 30th August.
Lordship.
Yeah.
Not extended. There is a that I will file reply by 30th.
And you have 5 days?
3rd November. Because it's a neuro problem. He became numb. The petitioner became numb. There is some.
Numb for what?
He couldn't move. He has suffering of bedridden because also attack of paralysis. So he couldn't come. That is not. I have got also medical certificate. I have enclosed with the application that he suffered. That's why he couldn't file it.
Nothing has been done. You have not decided anything.
That to be decided. Next too.
When
Annex 8.
When can we?
No, already filed.
Already filed.
Already filed. Annex 8 is there.
This has to be taken.
Yes, sir. That is so.
This is on an earlier occasion.
Similar method to item number 7.
Very ml.
Similar method to item number 7. Regarding lifting of 90 ml and 180 ml. The IA may be allowed.
What I,
Number 2 and 2 to 3.
what is that?
In the meantime, I may be allowed to lift 90 and 180 ml.
180 ml we have permitted. I am disposed of with this. Okay.
Item number 10.
Maybe.
Short,
Very simple. Very only lordship,
short.
lordship, only deletion of a clerical error. Perhaps they have taken to law, lordship 42(1). Lordship kindly the collect
42(1)
of the lordship Orissa excise, lordship that is the rules, Orissa excise rules 2017. Condition,
It says no transfer.
Lordship, transfer.
Partial
lordship,
of a license is permitted except with the prior permission.
lordship. Here is no transfer, lordship. Only lordship deletion of some names on the license itself. There is no transfer at all. And collector has recommended.
So why?
Collector has approved, lordship. Lordship kindly see it.
No, then what is a clerical error?
Only some names to be deleted because some of the lordship, not partners lordship, someone named in license, they decided to delete their name. License is intact, lordship. License is there. There no touch to license. License there. Only they are saying plus delete these names, lordship. So that has been approved by the collector, who is the competent authority.
Correct.
Then commissioner says, no, it comes under 42(1). Please apply fresh, lordship, for license.
But I'm like sorting.
What are you talking about? This is really a transfer.
Annexure 5 and annexure 4 and annexure 6 will
No,
randomly.
he intended to achieve something. I understand. Giving a very nice, vibrant color. His motive is something else. That is what is apparent. But anyhow, take instruction. How 1 week, next week we are giving.
Next,
Small matter will do.
lordship, no pursuit action.
What pursuit?
No,
They will not
if,
take.
lordship, grateful, lordship.
Item 11.
The petitioner is the licensee of one country liquor shop in the district of Noagar, the Purushottampuр
Country liquor.
country liquor. That is government approved country liquor, where the Aska 40 liquors produced by the supplied by the.
Whatever. Then what is your grievance?
My grievance is that I procured 2,165 liters of liquor from OSBC Khordha depot for destination to my shop. But it was coming by a rented vehicle, hired vehicle. The driver of the vehicle has deviated the route, so it was detected at Jotri and a case was registered and it was seized. And then it is put to publication, going to be tomorrow for publication without giving me any opportunity of hearing. And the notice is issued by the OIC of the Jotri Excise Station, who is not competent as he is a sub-inspector, because the confiscation and auction are the exclusive power of collector or authorized officer, which is not below the rank of superintendent of excise.
Where do I get it?
Annexure 8 minor.
No, law.
Law is section 71,
Yes.
subclause 3,
Yes.
2. The OIC should produce it before the collector or the authorized officer, who is not below the rank of a superintendent of excise.
I'm just asking where, say, 71?
71 within bracket 2, clause 2. Section 71.
Section 71.
Section.
Say so. No, so where it says that no, it is the officer who sees is not said to be below the rank of a superintendent of excellence.
No,
It is he, after the seizure, he has to produce before the collector or an officer who is not below the rank.
below the rank of superintendent of excellence. And after the confiscation is made, the confiscation will be made either by the collector or the authorized officer.
No. Where confiscation?
Section 71 clause 3. Only the authorized officer or the collector can.
No. There are two situations. 71 says any officer can seize the property except where the offender agrees in writing to get the offense compounded under section 74. And thereafter, the seized article will be produced before the collector or any officer not below the rank of superintendent of excise. So it shows that other than the collector or any person not below the rank of superintendent of excise, if he seizes the goods, then this is obligation. He says where collector has seized.
Here in this case, my lord, collector or also superintendent has not.
Correct. It says where the collector or the authorized officer seized any property.
Or when the property seized is produced
before him under subsection 2. He is satisfied that the offence has been committed. He shall, without prejudice to any other punishment to which is liable, order confiscation. So collector can order or authorized officer.
My lord. But here the OIC, which is rank of sub-inspector, has put it to notice for auction sale.
So he may be an authorized officer of the collector. What?
Let's you kindly see the impugned notice under Annexure 8, Miller. This is only a cell notice, Miller.
No, sir. First thing is, if the confiscation or the seizure appears to be wrong, then in that event that you have already issued a notice to sell.
I'm coming to that.
No, question is the first thing is your authority to seize.
Miller, confiscation proceeding was initiated, Miller. It was, let's say, we'll find that Annexure 5, page 32,
Cannot be done.
page 32, Annexure 5, let's say, kindly see.
These source.
Annexure 5, page 32. This is the summon issued to him in a confiscation proceeding that was pending before the superintendent of excise, Khordha. Page 32.
One C. Who is it? Here.
Well, page 30, so let's say collection.
C.
Superintendent
is the superintendent of this club. We want this superintendent below.
And under three, he has proceeded. Now he is optional.
Now, Miller, the document which is not annexed to the writ petition, I am submitting.
What are you saying, sir? It has been
The confiscation order is passed by the superintendent.
This was
Yes.
served on him.
Yes, Miller. Notice was served. He appeared, he filed a time petition for adjournment. Director order is passed, Miller.
So compounding, he did not agree.
No. He has suppressed that point.
My lord, this order has not been supplied to.
What are you talking about? Sir, your client has appeared before the authorized officer and then sought for a time.
My lord, that is the first.
I am suffering from a viral fever. So please, I cannot make myself present on that.
My lord, that I have.
Paragraph 7.
Repetition paragraph 7, Milan.
Yes.
He has admitted.
No. My brother is talking about something else. You are in your instruction.
Earlier approached this court.
My lord.
Approached this court earlier in 48620 in this connection.
No, my lord, I have this petitioner has not approached.
Then what is this? 486202525?
Find out this number.
What is this case, sir? WPC number 486202025.
That is a vehicle owner or petitioner.
No. Milord, I'm explaining. Milord, this is the instruction is given to us. That is in the diary number, Milord. Diary number of this case is 4260.
So,
Because
not WP.
not WP, Milord.
Okay.
Because we are sending this soft copy for instruction. That's why, Milord. That's it. Trying to see page 7, paragraph 7.
Yes.
Paragraph 7 towards the bottom, Milord.
Page.
Page 6 of the repetition. But the petitioner could not attend the hearing as she was on pilgrimage. But in the in the adjournment petition,
Viral fever.
viral fever.
So what?
But the advocate for the petitioner appeared there. He submitted time petition. Thereafter, order was passed.
Where is the copy of the order?
Last page, Milord. Last page.
Oh.
After passing of this order, he has to file an appeal. 71 subsection 6, Milord.
He has not put it, he has not disclosed this. This order has not been disclosed by him.
No, Milord.
My lord, I am not aware of that order, which is behind my back.
Then why is it not done?
Once only.
No. Breaking can't be. He's not saying breaking. He is the license holder with allegation.
Liquor, right?
But he has sold this outside his jurisdiction. Supply. But he is containing that the drivers were delivering to me on the authorized report. Detoured it. And during that it was. So this is what is the slow setup. And there are also different.
Now he has to file an appeal, Milord. 71 6.
Short application with this procedure. Sure. One before. Please, next.
With reference to notice for the personal hearing, I appear before the personal hearing, your lordship.
So what you go to the tribunal, you will.
My lord, yes, my lord, my appeal has been disposed of on the ground of non-payment of pre-deposit and also on merits, your lordship, without considering my merits of the case, your lordship. I have raised the put forth,
But you can challenge this order to a tribunal.
my lord, I can travel this, I brought.
So
But-
now they have taken out one particular notifications where they permit all those appeals to be filed within a time lag. So you can then avail 10% deposit, you have to make that the condition precedent. Challenge this order that they cannot dismiss this appeal of the ground of no pre-deposit, non-deposit or something or whatever. Raise that point.
My lord, this is with regard to service tax, your lordship.
Service tax.
Yes, my lords. I have already made the pre-deposit 7.5% prior to hearing of appeal, your lordships. And also I have put forth appear before the personal hearing and the non-payment of pre-deposit never led to my knowledge, your lordship. And I also submitted a written note, your lordship.
Shouldn't be brought to your notice that you have not made the deposit.
These are conditions precedent.
That appeals have not to be entertainable. Appeals have not to be entertainable.
Dismissal certified by you
But-
know what to satisfy.
But I have deposited my lord prior to personal hearing. I have deposited the amount, your lordships.
Can it be done after the limitation period?
Oh, yes, my lord. The statute says,
I know one judgment of the Supreme Court just reversed.
my lord, that
That
is.
is what I said, Saranagar or Barasa? Barasa.
But
There also, there was one act
yes, my lord.
which says that before you initiate the proceeding, you have to make a pre-deposits. That is condition precedent for filing. And there is a period of limitation provided for filing an appeal. Then the question arose that whether this pre-deposit, there can be any extension of time beyond the outer limit of the limitation for filing an appeal. May I be more clear? The act says that a person aggrieved by an order can file an appeal before the authority or a court within 6 months.
My lord.
There is no power given in the statute permitting the court or the authority to extend beyond 6 months. Outer cap was given. In that, there was a provision that while filing such appeal within 6 months, you have to make a pre-deposit. Then the question arose that whether the court or the authority can extend the time for pre-deposit beyond 6 months, which is an outer limit for filing an appeal. The Supreme Court in Barasat says no. If the power to extend beyond 6 months is arrested, then there is no power reserved into the authority of court to direct or extend the time for deposit beyond 6 months. Same question. That is the Supreme Court judgment in Barasat Medical Hospital or Barasat. Find out that judgment is a Barasat.
74B.
My lord. 70, yes, my lord.
So.
My lord, that part is there. I cannot.
Then the Supreme Court has already taken care of that and had adjourned all the matters and act.
But in this case, my lord, there is procedural irregularity, my lord. Can they overcome?
Not a procedural irregularity, sir. This is a substantive irregularity.
My lord. My lord.
Not a procedural.
My lord.
This is incidental correctable.
Incidentally correct.
74, 74(3) or something.
73(4)D.
4B.
73(4)D.
So
That limitation period is there. But my lord, when
Is the decision of the matter.
but that,
restrained all the high courts.
yes, my lord. As in that SLP no 5432, my lord, I am conscious.
As per my brother said, it is fixed for hearing on 17th of December. With Supreme Court.
Maybe, but Supreme Court has.
Said that we should not, and no coercive steps in the meantime, that is what the Supreme.
Yes, yes, my lord. Till disposal, no question.
Similar order will pass.
74 order.
Similar order will pass. Let us see what.
What is the outcome of it? But look at that Barasat judge.
I will go.
Barasat medical.
Barasat
Hospital.
Got it.
That is what, my lord, I was interested. Since that on this one,
I understand, sir. That is why I am telling you this is how a judgment is there.
my lord, exactly, my lord, that is.
Yes, that's what I
You have that order.
No, my lord, similar.
No, sir.
Rectified.
Court gives.
Yes, my lord.
Yes, ma'am. Item number 14.
Only question is, my lord, whether after, even if the 73(4)(b) is decided in his favor, now in the appeal is rejected on the ground of my submission is only for your lord.
Report is exactly.
Next. Item number 14.
Now, see, this is regarding 1010 bylaws. And also disposing due to non-functioning, we are filing members.
Yes, we are disposing of. Yes.
Both the metropolitan.
Yes.
Order.
So have you deposited 10%?
Last year, the final appeal had deposited, I'm denied it deposited.
Why? Then you have to deposit
Minor, sir.
10%.
Yes, last.
Item 15.
Similar.
Item number 16.
73(4)(b).
But in item 3, there is the matter has been disposed of. But when the appeal, the assessment order was went in his favor. After that, review was made by the commissioner, and the commissioner has filed an appeal before the commissioner appeal, and that is pending. And the hearing is also been notice has been issued for the hearing. You will not see.
The OIO has been passed
70
after 1 year.
Now, OIS will pass in his favor.
You go and contest that. This is 32791. What item you said? What is the number?
32791. Yes.
Can you give me?
The so forth is dated 31st
No,
of.
no, that order went in your favor.
Yes,
Then the review or the revision is filed by the department. There is a pending.
Mr. Pedia,
So,
revision is made post and post favor. In the original assessment order itself is the regard will find private sale. Just can your commissioner revive it?
No, this is a responsibility. He has a right to move. So let it be decided. It will be, we will discuss the case. So he will not be an aggrieved person.
My lord, even the review is timeline.
Understand, that's why I'm saying that
You raise that.
you raise that.
They have admitted the appeal without.
Then you challenge that order.
I'm not agreed by the.
No, this, they have agreed, an order of admission. That they cannot beyond the time, they cannot admit. Order is bad.
I have to challenge the review order. In this writ petition, I have challenged the review order.
Where?
In the first paragraph itself, I have written.
And the full order, can you show me?
Review order. 24, Annex 3.
Is there any, no, this is the 9/4 or 30th of October?
30th of
24.
Wait.
No, you are talking about 9/4/2023. Review order dated 9/4/2023.
30/10/2024.
Annex 3.
Annexure 3, are you looking at it?
24.
But it is the 30th October 2000.
30th October 2024.
Whereas, where he is saying, Okay, so the review order dated 9/4/2023 passed. So I'm just talking about NHL 3 is not a 9/4/2023.
Maybe surprise.
So I faced some of myself. Yes, he has said NHL 3. But NHL 3 is dated is wrong.
Perhaps he has many other similar matters.
Date is wrong.
Hurried in filing.
No, the review has already been disposed of.
Notice has been issued.
No.
Against
Such
review,
and such is not legal and proper.
If
And
review
then
the
he says
assessing,
that he can file an appeal before the commissioner.
we have already filed an appeal and notice has been issued. Page number 42, Your
If
Lordship.
he's challenging this order and saying that this review is also time barred, you could not have done it. Then how can he direct? This order has to go. He can challenge this order. Get it? Appeal is the resultant effect of this order. Is because of this order.
No.
If this order goes, then the appeal will go.
the review has to be passed within 3 months. He has passed after the expiry of 3 months.
No, we should admit all that. Where is the provision?
There is no alternative remedy.
We have already filed an appeal.
No, sir, against this order of review.
He has no remedy.
What is his remedy?
Your Lordship. In this
A order of review. Is passed.
Review of commissioners. They sit over the order of the
assessing officer,
assessing authority
adjudicating officer.
to consider whether to file any appeal or not. That is the order.
No, Lordship, the adjudicating officer has dropped the proceeding. After that, commissioner has taken this matter and reviewed that it is a tax.
To file appeal.
It is a taxable and file an appeal. No,
Department will file appeal or
appeal,
not.
appeal.
So this is in a way an administrative function.
No, activity. Order.
No. My lord, the provision is quoted at para 11. The principal commissioner of central excise or commissioner of central excise may, of his own motion, call for and examine the record of any proceeding in which the adjudicating authority subordinate to him has passed any decision or order under this chapter for the purpose of
We are on one aspect that suppose the commissioner does so under this provision of section 84(1). Correct? Then what is the remedy of an aggrieved person against this? No other remedy. No other. That is what we wanted. So the only remedy is the writ. No problem. We are thinking in a different line. We were thinking something else. So this is the only remedy which is available to you. Yes, we will admit it. Admit it.
the appeal proceeding needs to be scaled.
It has to be stayed. And subsection 2 says it should be made within 3 months. Come up with the line of judgment, both sides. You have one principles in your favor. Yes. Admit. Don't repeat next. Or.
Actually, notice.
Others are disposed of. 74.
Pending.
74. Don't send it. This should
Notice.
2 weeks time, once we rejoin the, should come after 3 months.
Item number 17. Yes, ma'am. 17. sir.
What point, Mr. Kedia, you will argue? Any idea? Go.
Item 17.
Yes, please.
No, non-constitutional tribunal.
Yes.
Item 18.
73-4.
Item 19.
19, in absence of the GST tribunal.
I know for sure. Item number 20.
We are suspended office lodging not in a place.
Yes.
21.
The matter relating to the custom settlement. But the very issue needs naming manner. The person who has filed this case, he is the officers of the department.
He is the officer of the department.
Officers of the department.
He is the officer of the department.
Then the authority has imposed penalty against that person as if he is a importer. That's why I come before my laws. That's why I come before my laws. I am not importer, I am not exporter, I am only
And
officer.
there is no departmental proceeding or disciplinary proceeding.
They have to fight, they have to do, but
They have to do it, but have they imposed penalty?
They have imposed penalty. That's why I'm before my laws. How an officer will be nationalized.
He is an officer or an employee in the custom. In the custom department.
Custom department.
So, how can he be termed as an importer? He must be doing some misdeeds and must be doing some wrong things. I can understand. Take an action, it is permissible under the service law.
Well,
The HCA will appear in this matter.
Will
take instruction in this matter.
What instruction in the matter? It's an open and shut case. There is no denial that he is an employee of the customs department. Where is Mr. ASG?
We'll take instruction in this matter. This is for the fastest and earliest company will go.
I have this matter to bring your kind attention. Section 155 of the Customs Act, where the officers are being protected by that itself.
No, that is what the action, but 112.
I will give you kind attention to
112.
section 150.
What about 112?
112 for imposition of a penalty.
For who?
Not to the officer.
This is kindly consider.
Then I bring your kind attention section.
Please read section 1.
Section 112B.
No, please 1121.
112.
Please.
Penalty for improper importation of goods.
Yes.
Any person.
Now, it does not define which person. See, any person.
That's why I bring your attention.
Please come any person. Then come A.
Who, in relation to any goods, does or omits to do any act, which act or omission would render such goods liable to confiscation under section 51 or abates the doing.
This is also abating, the abates the doing or
omission
omission of such act. So he is in, shall be liable. Then another Roman 1 and 2 has come, which imposes a penalty.
Then B.
B.
Who acquires possession of means that importer or is anyway concerned in carrying, removing, depositing, harboring, keeping, concealing, selling, or purchasing, or any other manner dealing with any goods which he knows or has reason to believe are liable to confiscation under section 51. So it is the importer.
Sir, between A and B, there is a word which you are not putting in brackets for. There is a word which is called or.
Then I B.
So, if you come under A, you will not come under B. If you come under B, you may not come under A. Because in these two situations are different.
For this reason, I bring the time of section 1.
Yeah, ways the doing. If you facilitate, if you help, if you do something which really comes within 111. Why not?
So section 155.
That is any act done in a good faith, public officer. I understand.
That in 115, when the issue notice to me, I have give reply to the authority. I am protected as an officer.
112 this
150. 155. Section 155, madam. I am the page 46 annex 1.
These are
Madam, as per section 155, madam.
It is there in every act, sir. It's the omnibus law which is apparently in every act.
For this provision.
Does it override? I am again saying. If there is a special clause which provides a penalty, and there is an omnibus clause which will prevail. Under the statutory interpretation, which should prevail. Special provision and the omnibus provision or general provision.
And here is the case, the department has.
I am again asking, sir.
Section.
The word any person does not define which person, importer or exporter.
So in this regards, my lord, when I am filing application before the authority, I will be protected by this provision.
What is the remedy against unrest corruption? Which is 129. You don't have to apply this. 129A. Yes, sir. 129.
One 29A appeal to appellate tribunal. 128, my lord. Appeal to commission appeal.
Yes.
Sir, any person agreed by any decision or order under this act by an officer of a customs and the order passed by the customs officer lower in the rank of commissioner for customs may appeal to the commissioner of appeals within 60 days from the date of a communication to him of the such decision or order. So it is only meant for the importer or exporter. But so for this reason, you have to make a clarity.
This 112, the order, who has passed the order? Final order?
I'm going to pass by the additional commission.
So
Final order passed by the additional commissioner.
back, is it lower in the rank of the principal commissioner of customs?
It is lower. Additional commissioner lower.
Rank
Lower.
128 provides an appeal.
My lord, I do admit, my lord.
Yes.
So I also file appeal. Not I not file appeal. I also file appeal. In appellate commissioner has not agreed and he stated that section 155 of section 2 is applicable to you. Against that order, I go to the sister. Sister of the pass order saying that it is not applicable. That order I have unaccepted. If you actually want to this thing unaccepted and have a glance. Yes,
Can you file an appeal before the commissioner?
appeal, yes,
You filed
I have been.
after the order of the commissioner,
Then go to tribunal.
you went to the tribunal
Well,
and the tribunal also disposed of.
tribunal is saying that section 155 has to be examined by the
What is
different
the
tribunal.
order of?
That is annexure, minor. Annexure 10 minor, page 224. The relevant portion minor. That's relevant portion 241 minor. There is paragraph 17. Paragraph 17 to 41. The relevant portion of the tribunal's order. Consequently, the findings of the interim order are set aside. And the submission of the appellants leading to the proceeding before us are left open to enable fresh decision. In resumed adjudication, we taken to logical conclusion for consideration of the safeguard claimed to have been breached. We also leave no room for doubt that the judicial observation of the scope and the extent of the project should inform adjudicated regulation of the plea of the appellants here. The appeals are allowed.
He has remitted back.
To the
He has
appeal.
remitted to the authority to take into consideration that immunity which is given under.
Obvious, man.
Fine.
Man.
Why you are agree?
So thereafter, original authority.
Well, I have not agreed. Man, that's so after that.
Thereafter.
Thereafter they passed
what
order.
happened?
Thereafter they passed order. Before the additional commissioner decide the case whether 155 is applicable to us or not, but he has not decided anything. Then order in original passed by the additional commissioner without answering that point, and he is only disposed of entire thing. That is annexure 12 mile. Order passed by the additional commissioner. That's why I come before my lords.
Which order you are challenging?
Now I am challenging the show cause notice which has issued and along with the order of original because the section one.
Notice was issued after the order of the assessment or before the order of.
Before.
Before. So you participated in the proceeding on the basis of a show cause. The order in the original went against you. You preferred an appeal before the commissioner. Against the order of the commissioner, you went to the SESTAT. So there was a sufficient compliance on the basis of a show cause. Now the SESTAT remitted back the matter to the authority to consider whether this immunity provided shall be extended to you.
That's not decided.
You went back. You went back before the original authority passed this imputed order.
This imputed order, which one challenge?
Will be read live.
The annexure 12, that is order dated.
And you can go and resign from your other stand and challenge these focus points.
We are still in the.
Yes. Is it not further available to be challenged before the other?
My lord, once we are not a dealer, we are not a assessing, we are not an importer, not an exporter. So it is only made for import and export.
The farcical that everything should come to the High Court in a jurisdiction. High Court will decide on the evidence whether you are an importer, you are an exporter, you are a handler, you are a transporter. Authorities are farcical.
Authority has already decided.
For any other purpose, everything will be decided.
My lord, authority decided.
The statute has created a forum.
So Customs Act is always
Go
made.
there, if the statute provides a remedy, why High Court? You have availed the provision of an appeal. Earlier, you availed the provision of an appeal before the apparent criminal.
No, when.
Why this time you will pass?
My lord, when.
If they have violated.
When I am raising the very question of a maintainability. We're raising the very question of a maintainability, but without deciding the question of maintainability.
To some extent, that matter was relegated to the authority. If the authorities have not acted in accordance with the SESTAT order, then go and show it to the appellate authority. How can an original authority defy the order of the SESTAT? Appellate authority is competent to decide. He can. But why rich?
No, when he has. When is 1 second relegated the matter to that authority.
The Paradhi court or what?
It is Bombay.
Then how you can move a writ petition?
Because the petition is now working at Bhubaneswar jurisdiction. So order communicated in Bhubaneswar.
Can you hear communication of an order when the entire proceeding held up somewhere else? Gives a cause of action to this court.
It's not service matter.
Service matter. All the persons who are being affected, they all are filing writ in different high courts.
No, that is what I am asking you, whether this High Court can intervene. I am talking
High Court can entertain, man.
show me in the judgment of the Supreme Court, followed by in alchemist by the Supreme Court, under Article 226, Clause 2 of the Constitution. How can a jurisdiction be created? Then if you are again transferred to Assam, then you will go in a Guwahati High Court and do it. You are again transferred to Kashmir, then the Jammu and Kashmir court will have the jurisdiction. Is it?
No matter that case, they didn't have a jurisdiction. Only the case of any dismissal, retirement, any communication is made to them, that is a cause of action. Otherwise, they don't have a communication.
It is not a.
Otherwise, you don't have a locus standi to file the case before this judicial.
Not a service matter. Sorry. We are dismissing on the ground of the jurisdiction.
No, I cannot dismiss the matter. I will super if you I want to withdraw the petition and approach the Bombay High Court. So am I permitted to withdraw the petition with regard to approach the High Court of Jurisdiction of Bombay?
This court has a. Withdraw?
It's in absence of the GST tribunal.
Wait, please, Millets. Millets, I beg to appear virtually, Millets. Wait, please, Millets. Millets, I beg to appear virtually. Millets, I beg to appear virtually. Millets, I'm a little under the weather, Millets. Millets, the short point involved in this matter is that by virtue of section 158BA, capital B, capital A of the Income Tax Act, Millets, once a search is initiated, the pending assessment shall abate. That is the provision itself. Here, Millets, is a case. The assessment order has been passed during the after the initiation of the search, whereas it should have abated. That's the short point. And therefore, Millets, the assessing officer did not have any jurisdiction at all to pass the assessment order. 158BA.
158BA.
BA, Millets. Notwithstanding 158BA1, notwithstanding anything in any other provisions of this act where on or after the first day of this September 2024, a search is initiated under section 132 or books of accounts, other documents or any assets are requisitioned under section 132A in the case of any person, then the assessing officer shall proceed to assess or reassess the total undisclosed income of the block period in accordance with the provisions of this chapter. It is subsection 2 which I am relying upon. The assessment or reassessment or recomputation under the provisions of this act are other than this chapter, if any, pertaining to any assessment year falling in the block period, pending on the date of initiation of the search under section 132 or making of requisition under section 132A, as the case may be, shall abate and shall be deemed to have abated on the date of initiation of search or making of requisition.
There cannot be a parallel assessment or assessment.
That's the statutory idea.
It means it may be a composite period covering the years.
So block period means below 6 years.
Was it pending prior to a search?
Yes, it was pending as on the date of search. The search was made on 26/11/2024. And it was pending as on that date.
The search was made when?
26th November 2024.
Oh. Yes, how can you then, what is the nuances of this 158B?
And just to clarify, Millards,
You are still within your domain or a power to make an assessment. But the assessment under this chapter, not an assessment in a normal manner. You can do it here. It gives you a fresh lease of life to you. Not individually, but even collectively you can.
The instruction, because it's the
What
source,
instruction? It's a pure question of law. What is instruction?
like the source and seizure matter, man. So
That is what he says, that yes, it is a search and seizure case. The moment the search has taken place, then any pending assessment which is there, which covers within that block period, then it will automatically abate. And now the authority under this chapter of search and seizure, he will assess.
That's
the spirit of this section.
And also there is a judgment, Millards, which my learned colleague will Millards hand over to your lordships in case your lordships needs assistance of it. So it's a judgment of the Honorable Supreme Court. Principal CIT versus Abhisar Buildwell. That discusses about this. Millards will straight away take.
You also say that if already done, that would also abate. Very interesting and stringent provision. What are you doing? It is only for the sake of adjournment, nothing more. Which paragraph?
Millards, I rely Millards on para 33. Millards will see. This Millards takes into view the earlier provision. 158 BA came into the statute book on 1st of September 2024. Prior to that, 153A was the pari-materia provision, and 153A Millards provided this very. Your lordship will see what 153A provided. That is at section para 32.
Is a time period which is different.
Para 32, 153A is quoted, which is identical. It's a pari-materia.
The time period is different because there after the 31st day of May 2003.
Millards.
Here they have included after 1st of September 2002.
Millards. Only the time period is different.
I know.
So, para 33 Millards is the discussion. As per the provisions of section 153A, in case of a search under 132 or requisition under 132A, the AO gets the jurisdiction to assess or reassess the total income in respect of each assessment year falling within 6 assessment years. However, it is required to be noted that as per the second proviso to section 153A, the assessment or reassessment, if any, relating to any assessment year falling within the period of 6 assessment years, pending as on the date of initiation of the search under section 132 or requisition under 132A, as the case may be, shall abate. Then Millards, 36 is the conclusion.
So that's a very, very pragmatic view which has been taken. That the search or a seizure may happen. And if it does not yield any incriminating materials,
Millards.
This proceeding will also lapse and the other proceeding by virtue of this will abate. The court saved those that the abatement may take place, but in the event if there is no incriminating materials found, then it will revive.
Millards. It will revive from the stage it was.
Yes.
Para 36 is the conclusion.
Yes, I have already read it, that's why I'm saying.
Grateful.
That's a very pragmatic view which is taken. Interest of the revenue is also taken there.
It is all protected. There is no escapement. Millards.
Then you can thereafter revive it and then continue. Individual assessment. Instead of loss assessment, abatement, then what job it is roll on? No, even that people, it's not written the law, it will go. That means it is noted, it's not written. Ultimately, the substitute, no, yes, then they cannot reassess. They cannot reassess other bases. Then this proceeding also goes, because of the investment, and proceeding also. So. That's what this do it.
No, one time, such time,
Unnecessarily, this section is very clear. And the Supreme Court has taken a very pragmatic view in this regard. Saying that yes, definitely it will abate.
and very
It will abate, no doubt about it. But in the event search and seizure does not yield any incriminating material, or there is a suppression or a gross violation or everything, then in that event, ACC cannot have us or cannot steal a march merrily from both the ends. Here also, he was successful, and by virtue of operation of law is that also goes. Supreme Court says no. Once this ended, it will revive.
Milos, it's a very revenue neutral situation, Milos. The interest of the revenue.
That has to be. Dispose of. We can't sustain it. We'll say that set aside proceeding to remain abate or kept in abeyance as an abated one by virtue of this section 158BA.
BA2.
BA contains everything. What more? And complete the exercise as a block period under that chapter. With the rider, as the Supreme Court has said, that in the event in search and seizure proceedings, no incriminating materials are found, and then you can't make a reassessment, then in that event it will remain. And the period shall be excluded under the General Clauses Act as well. Don't shoot it.
For delivery of order W1275 of 2025.
You not see if
We discuss being the scope and jurisdiction of the traveler constituted under section 24A of the Act, and the dispute comes within the four corners of the said jurisdiction. Therefore, the challenge of an order dated 27 March can be made by approaching the said traveler, with us do not find any informative and illegality in the issued order. The feeling of dismiss. We have defined grant in aid. And
What? The mention or the make of the. It's called.
WPC number 34559 of 2025.
Here, my lord, the order dated 31/10/2025 tasked with the land acquisition, Tahsildar competent authority under the land acquisition is imposed for my lord. Lordship, what happens?
Where is the order dated 31st of October?
Lordship, Lordship. Is it 44? This case is taken up today.
Yes. Order of this, I am not getting it.
This 44, my lord.
Page 44.
Yes, my lord. 31st and 2025. Starts from this case is taken up with.
So your amount is also kept in the bank.
Yes, my lord.
So
my condition
claim
is
half, so that amount has been given there.
My lord, my concern is that the land was acquired under the National Highway Authority Act. So, my lord, when the section 3A of the core of the National Highway Authority Act 1956 shows that if any dispute arises, an objection relating to apportionment, then it is the duty of the competent authority under the Litigation Act to refer the matter to Principal Civil Court. I objected because what happened in this case, my lord, one branch.
No, you came and claim the half share of the entire compensation.
Yes, my lord.
So you cannot go beyond half share. That is your admitted position.
Yes.
He says that the half share will be adjusted in the bank deposit. It will not be disbursed to the other co-sharer.
But prior to 31st time, lordship see the order, my lord.
No, this is the order, the ultimate order which supersedes all the earlier orders.
My lord.
So what is the difficulty?
My lord, the lordship kindly belongs to section 3H4 NSI Act. The moment the objection is filed relating to apportionment, duty has been.
Sir, your admission is there. You have approached the authority for disbursement of the half share of the compensation in your favor.
My condition is that, my lord.
The court has recorded. You say that another half share will be fixed in the bank.
And subsequently, he is directed to break the.
What subsequently? But you are challenging this order. You are not challenging
Yes, my
any
lord.
other order.
And I have challenged that order at 31st 10, all consequential order, my lord.
Will you not specify what consequential order?
If my lord 31st 10 order goes, which is the very root.
How can it is done on your admission?
My lord, my condition
Your
is
admission is
my
there.
lord.
And he has passed the order of taking your admission.
My lord, the language shows that lordship is permitted to read, my lord.
I have read it.
My lord, my condition is that my submission that the moment I file objection before the competent authority.
This is not. He has recorded. I am reading. This case is taken up today. Both parties are present. Objector, you has submitted the certified copy of the CS number and a petition not to disperse the compensation amount till disposal of such information. Mr. means you. one legal heir of late such and such has prayed for, you prayed for disbursement of half share of the compensation in their favor. That is the legal heirs. And another half will be fixed in the bank, the disposal of such. In view of the above, LA section is directed to issue a letter in favor of the concerned bank to know the bank detail statement with interest amount for calculation and 50% payment of the compensation amounting to your father, mean legal heirs, such and such, is directed to obtain a fixed deposit. So you claim half share. They have said that yes, there is a dispute. I do not know what will happen. I am just making this amount 50% in a fixed deposit. What is the difficulty?
Well, kindly glance to
Your share is safe, subject to the adjudication in the partition suit.
My lord, kindly glance to page 43, the last order dated 25/10.
The subsequent order precedes.
My lord, my submission is that the moment objection is filed, it is the duty of the competent authority under the.
You did not raise the objection.
Yes, my lord. Yes, my lord. The previous order I have raised objection.
Nothing.
Yes, my lord.
Subsequently, you say that your amount should be disbursed. I want a 50% of the total compensation to be given to me. The court, the authority has saved your 50% amount.
My lord, that
What
is the
more? The protection has been given. Ultimately, in a partition suit, it may happen that your share may not be 50%. It may be 30%. It may be 40%. That will be decided in the partition suit.
that's why because my
You
lord,
cannot go beyond what you claim. You claimed a 50% share. He has protected the 50% amount.
my lord,
That's all.
my lord, my submission is that in the meantime, the OP number 6 to 8 had executed sale deed in which favor there was compensation granted.
Sir, we go and challenge that. You go and challenge as provided in the statute.
My lord,
You can't have a cake and eat it too. Both.
My lord, as per the statute, my lord, the moment objection is received, it is to be referred to the
Which section you are referring?
section 3H, subsection 4, my lord.
Of the National Highways Act.
My lord. If any dispute arises as to the apportionment of the amount or any part thereof, or to any person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court of original jurisdiction within the limits of.
Correct. What was the dispute? That you said 50% belongs to me.
My lord.
There was no dispute. Other side has not objected to it.
Because, my lord, the compensation has been assessed on the basis of the correction of or wrong recording of rights.
Sir, then you have to challenge the entire proceeding leading to a determination of the compensation. Have you challenged?
That objection I have raised, my lord.
No. You
And-
have to
and-
raise an
and-
objection.
my
You
lord-
have to raise an objection
My lord,
under section 3. Under section 3, C.
and hearing of objection. Yes, my lord.
You did not raise because
No,
the
no.
time limit is given that within 15 days from the date of the publication, 21 days from the date of the publication, you have to raise objection. You simply raised an objection on the apportionment because you say that my share is more than what they are claiming. The court has, the authority has accepted what you claimed as the share in the property. Then how can you be said to be a prejudiced
My lord,
person?
my submission, my lord, that the entire compensation was assessed and
Then you
deposited
have to-
on the
then you
basis
have
of a wrong recording of rights.
There is a distinction, sir. There is a vast distinction between a quantification of a compensation and the apportionment of the compensation.
But I'm
When
not.
we talk about the apportionment of the compensation, that presume that the compensation amount you are not disputing, only
No,
the
no.
only the share.
Only share.
You are entitled to 5 lakhs
I do
or
consider
3
it.
lakhs or a
I
4
do
lakhs
agree.
out of 50 lakhs.
I do admit, I'm only confined to
If there is an admission, then no dispute.
because my
Your
lord,
claim is accepted.
no, my lord, lordship see that the starting page 35, my lord, the initiation of the LA proceeding, my lord.
Problem again, you are arguing, you are saying yes, and then you are arguing at the root of the determination of the compensation. Please consider. There is a line of distinction under the Act 1 of 1894, you know, distinction between section 18 and section 33.
Yes, my lord.
You are aware?
Yes.
Section 18, you can challenge the quantification of the compensation. Under section 33, only the apportionment.
My lord.
And you are referring this particular section 3H4, which only talks about the apportionment. That how much money should be given to you
Yes.
is the apportionment.
My lord.
And you claim that I should be given 50%. The authority has saved your 50%, says I am not going to disburse to them.
My lord.
What more?
My lord, my one solution, my lord.
You like to take a risk? But then we'll dispose of your.
Lordship, I will file objection and it will be considered. My lord.
That is up to you. We will not. Whether your right still subsists or does not subsist, we don't know.
Because, my lord, that challenging the correction of ROR, I prefer the mutation appeal. That was also reflected in the order sheet. And mutation appeal in the meantime dismissed.
Will the mutation determine the share of the parties in
My
the
lord,
joint property?
my entire case is that on the basis of the wrong recording of right, the compensation was determined.
The compensation is not determined on the basis of an entry made in the. It is the entitlement. It's only the apportionment of the compensation.
Lordship,
Nothing more than that.
Lordship, page 35 and the record of right will clear, my lord. Lordship, page 35. Because one branch has been deleted from the record of right.
Can you go beyond 50%? If that branch is deleted,
No,
that branch
my
will
lord,
come
no,
and raise an objection. You
no.
can't go beyond 50%. Your money is.
Lordship, either of them dispose of. With the objection, lordship dispose of. 50% be deposited.
They have already said 50%.
No, my lord.
Done same thing, sir. He has protected your 50% right.
My lord, why?
Compensation, whatever.
My lord, why I have challenged the order, my lord? Because the date was fixed to 31st 12. Without any advance petition, the land acquisition competent authority advanced the petition and passed the order, my lord. This is the that's why I apprehend that whether all amount will be dispersed or not.
You apprehend.
Yes, my lord. There is
Protected, sir. Yes.
because my lord, the conduct of the competent authority itself shows that when the matter is fixed to 31st 12, without an advance petition from any corner, the land acquisition officer.
How are you prejudiced? Are you prejudiced by that?
My lord, the manner.
You claim your 50% share.
My lord.
Your 50% share of the compensation
Lordship.
amount has already been saved, protected.
Lordship.
So it is subject to outcome of
Lordship.
CS.
Lordship, I do admit, my lord,
So,
but the manner in which the order has been passed, my lord, so it is fixed to 31st 12. There is no advance petition.
You were present on that day.
Yes, my lord.
So, what is the prejudice? Had it been a case that he has preponed the date and there was no notice given to you, you could not appear on that day, and the order is passed, we can appreciate this. But if once you have been given a notice and you appeared and made your submission, what more the grievance can be that they can't prepone the date?
No grievance. Lordship only observed that 50%.
What?
My interest be to the extent of 50%. Lordship.
Chosen a bad person.
No, my lord. No, never. While drafting the case, I also know the fate of the case, my lord. Because, my lord.
The saving bank account or whatever the
Nazir.
bank account
My lord.
of the Nazir. That's all. There is no direction for disbursement. No direction. Read.
My lord.
My English is very bad, but what I could gather is this. Where is the direction for disbursement?
Because no, there is no direction. There is
There, why you are every time you are coming disbursement today. It's so urgent. It can't wait. Money will go.
because my lord, the fixed deposit has been direction for fixed deposit.
That obviously it has come from a fixed deposit to a saving account or a current account. That does not mean that the money would be disbursed to the parties. He has to take a further call. He will decide whether to give or not to give. We are imposing a cost.
No, my lord.
Though it does not appear from the
So cost may be explained, man.
This is for very good cause.
No, my lord.
Let
I will
them-
be-
let them do it for these unprivileged children
Lordship, 25
who are
thousand.
languishing in a juvenile home.
Lordship, 25,000. Lordship, cost may be.
The here I have
Lordship,
I have really reduced my heart to a chicken heart.
Lordship,
There it never goes down six. Is for these
My lord, the
juvenile
petitioner-
children who are orphans, they have no.
my lord, the petitioner is a retired employee of OSRTC. Even he is not paid the his full fees to me, my lord. I submit fairly, my lord.
Has got a
Item.
retirement benefits.
No, my lord, the contractual employee of OSRTC.
Item 24.
Lordship, the cost part may be excluded, my lord. Lordship.
Convince my brother.
Lordship, may consider, my lord.
Yes.
Consider, my lord.
Little. If you take a conscious decision, I am agreed. I will not look at it. Convince my brother. Yes.
Lordship.
What to do?
From the very beginning, we have been asking.
My lord.
It should have been from the very beginning.
Lordship, may cost part may be. I have to pay, my lord.
Why you?
No, my lord, I have to pay, my lord, because
Tell him what my brother has said. Yes, call the next.
Item now 24.
Lordship, my only prayer, my lord. Cost part may be. Cost part may be, my lord.
Ask him what my brother has said to him. Who has taken a dictation? He will tell you.
Item 24.
Yes, 24, next. Tell him last part, which my brother said. Yes.
24, I pray for.
Tell him. Because
Senior Army Council is out of station.
this rate maintainable. We have delivered that. I think yesterday or today. This is fine. We have delivered a judgment with sitting with Justice Parker.
Kindly grant us.
Whether the rate is maintainable with this rate. Please go through the judgment.
So, what I perused for 7 days.
7 days. Okay.
Is eligible.
19.8 crores. Refund.
But I have to verify the region because 14C as your lordship knows very well clearly says the reason.
So each date carries some interest.
Your lordship annexure 5 series his representation every day a new representation. Some day from the date of deposit, some day from the date of order, from some day, and prayer is to dispose of the representation. Your lordship may kindly look into the representation. Every week one representation in one prayer. Some days it is from the date of deposit from 2002. Some days from 2024 the date of order. Some days.
So let us do one thing, because we will say that first representation, you will take a decision within 4 months. Then you will take a second representation, you take a decision within 2 months thereafter.
No dividend. We'll say so. Third representation, then also 3 months thereafter, within 3 months. So all the representation they will do. Yes, that would serve the purpose.
So the first case in 2002, in the tribunal, it is in his favor.
Your Lordship, remanded. Your Lordship,
Maybe. So ultimately, he succeeded again.
2024.
24.
The set aside assessment order has been passed on for 5/10/2020. His refund application is on 14/10/2020.
Whatever you have refunded, the original amount.
Your Lordship.
Only thing is, he claims that there was a delay. He could have refunded immediately. I am entitled to an interest.
Your Lordship, for 7 days. As per the statute. Yes.
So it becomes a static one. There is no flexibility. Only for 7 days. We will decide in a phase-wise manner, which I suggested. Yes.
So you took up the reassessment when after 2002?
No, Your Lordship, that is not the case. This is not in.
You take a
Your
decision.
Lordship, 2006 order has been disposed of.
Whatever days of delay.
Yes.
Let us. Is seeking for adjournment.
Next week. Yes.
From 25.
All the three matters are 74.
All of the X. Item 26.
All the appeals are dismissed on the ground of delay only. What? All the 10 and 10 good visits for all the I have to go to the tribunal, man. Or giving your office order. On the question of delay, all the officers.
Yes, the right of appeal to the trial.
And another thing, my lord, one typographical error is there. The description of opposite party number 1 is wrong. It is not state tax appeal, it is central tax appeal. In the writ petition.
Only.
We are not saying, we are simply saying to.
Yes,
the
but
tribunal
that
thing
that-
Yes.
Only
Will be corrected.
Item 27.
That's it. 28.
28.
Please give.
Single name.
Whether 10% has been.
There are two categories. One, they were 10% has already been deposited, where 10% is to be deposited. That will be the fresh one, not the
Yes.
So you just give me the list.
I'll-
All of you who are appearing, separately give the list of your case.
Each day, each year, 15
Some matters have been tagged.
One go, you.
I know it. We will keep it every day, at least 4 matters, 5 matters.
Yes,
Of
that's
all
what
of you,
common.
1 matter each or a 2 matter each. Give. Every day.
They can see.
Man,
It will be listed on every day. On a daily basis.
Item 28.
May I please, Your Honor? The question involved for your obsequious interpretation is your honor. There is a provision for waiver bills, 128A bills. Here's the provision speaks bills. Because if the assessee whose demand raised and reflected in the electronic credit liability register, 128A bills. Capital A, 128 capital A.
I do not find.
It must be in the new act also. Is available. 2020. 128 capital.
Because if you are not permission of placing yours, waiver of interest or penalty are both relating to demands raised under section 73 for certain tax periods. It's a non-obstante provision clause. Notwithstanding anything to the contrary contained in this act, where any amount of tax is payable by a person chargeable with tax in accordance with a notice, may skip one is not relevant. B, an order passed under subsection 9 of section 73, and where no order under subsection 11 of section 107 or subsection 1 of section 100 passed, or an order passed under. So this is order B. B is applicable in our case. Then, my lords, we kindly start pertaining to the period from 1st July 2017 to 31st March 2020, or a part thereof, and the said person pays the full amount of tax payable as per the notice or statement or the order. You will not skip notice statement. Your lordship is concerned here in this order, not statement. So the order referred to in clause A or B or C, your lordship is concerned in B, as the case may be, or before the date, as may be notified by the government on the recommendation of the council. No interest under section 50 and penalty under this act shall be payable, and all the proceedings in respect of the said notice or order or statement, as the case may be, shall be deemed to be concluded subject to such conditions as may prescribed. We have to have the benefit of 128(1) bills. Supposing somebody has filed appeal. Here is the case, I have filed appeal against the demand order bills. Because unless I withdraw the appeal, if the appeal is there, then benefit cannot be lost. Your lordship may kindly see 3, subsection 3. Nothing contained in subsection 1 shall be applicable in respect of cases where an appeal or writ petition filed by the said petition person is pending before appellate authority or appellate tribunal or a court, as the case may be,
and has not been withdrawn by the said person on or before the said notified under subsection 1. Now here, the amount is to be deposited, the whole of the tax bills, 128 bills, before 31st March 2025, which I have deposited. I will bring to Lordship notice the relevant page. Now, secondly, perhaps the appeal which I had filed, that was permitted.
They have notified that date of 2025.
Yes, yes. It is there. But and not only that, my appeal which I filed was withdrawn. That withdrawal order is also there. Yes, yes, it is there. So with all these facts, now there is a relevant rule for this also, corresponding rule to 128, that is 164 bills. Rule 164 bills. Yes.
It's also quoted, Your Lordship, in the body of the petition. That is at page 8. 8.
Page 8. Yes. Procedure and conditions for closure of proceedings under section 128A in respect of demands issued under section 73. Any person who is eligible for waiver of interest or penalty or both in respect of a notice or a statement mentioned in clause A, subsection 1 of section 128A may file an application electronically in form GST SPL1 on the common portal, providing the details of the said notice or statement as the case may be, along with the details of the payments made in form GST DRC 03 towards the tax demanded. Any person who is eligible for waiver of interest or penalty or both in respect, we are concerned with the 2 minutes of any person who is eligible for waiver of interest or penalty or both in respect of orders mentioned in clause B and C of subsection 1 of section 120D may file an application electronically in the form GST SPL2 on the common portal, providing the details of the said order along with the details of the payments made towards the tax demanded, provided that the payment towards such tax demanded shall be made only by crediting the amount in the electronic liability register against the debit entry created by the said order. I will proceed very yes. Because now, Your Lordship, I will now bring to my Lord's notice the relevant document, Lords, where I have discharged and how, Lords. Now, my Lords may kindly see page 50 belongs. Annexure 4, page 50. Yes. Page 50, it's a column which continues from page 49 at the end. My Lords can see 2B column, capital 2B. Yes, yes, absolutely. Credit entry effort through payment. And the total payment which I have made, Your Lordship will find at page 50, that is 32 lakhs.
67.
Column number 8 is the total column belongs. Towards CGST, SGST, and I just all that. The total aggregate payment which I made 32 lakhs 67,530. Now you must kindly come to DRC 3, that is DRC 7. That is total how much is demanded. Whether I have paid the entire tax in full or not. And what I have paid, my last kindly bear in mind the amount is 32 lakhs 67,532. Now DRC 07 bills, I will take my lord's attention to page 41. Annexure 1. Page 41. Page 41, your lordship will find a table bills. IGST 15 lakhs 21, CGST 8 lakhs 79, and SGST 8 lakhs 73, 8 lakhs 73 each. And total comes to 32 lakhs 67,532. Exactly the amount which your lordship found, page 50, which I have paid bills. Now
you have paid more.
No. Exactly that amount I have paid. Tax amount.
No.
Page 50, 32 lakhs 67,532, and here also same bills.
Where? Page 41?
Page 41, yes. Tax column.
Oh,
it is
yes.
tax column.
Yes.
Because interest and penalty minus. Now, your lordship may kindly see this amount your lordship got, whatever tax was raised in DRC 07 bills, that was fully paid. After submitting bills this with submission of SPL2 application for waiver of interest, and appeal was also appeal permitted withdrawal, my lords may kindly see page. Relevant page. Annexure 2. withdrawal application has been submitted.
Page 42.
Page 42, my lords. Your withdrawal application has been submitted successfully against so and so. So this is where my appeal was permitted to withdraw, my lords. And that is also, there is no dispute on this, my lords. Now, I will take my lord's attention why, despite of this compliance, they have rejected. Before, my lords, I take your lordships to improved order. My lords may kindly turn to, my lords, page 40, 40, my lords. Page 40, my lords, your lordship will find para-wise, my lords may kindly see the last one. Para-wise tax and interest liability. Serial number, ground number 3, IGST 1,36,352. And serial number 5, ground number 5, 8,73,000. IGST 13,85,102 million. So 1,36,352 IGST and 13,85,000 together is 15,21,000, which your lordship have already seen in the next page at 41. IGST 15,21,000. I want to finish lordship notice, lords. This bifurcation of IGST. Total IGST out of the total millions tax demand on the GST DRC 07 is 15,21,000 millions, and 15,21,000 in page 40 bifurcation my lords found. IGST 1,36,352 and the other one is millions 13,85,000. Now your lordship may kindly turn to millions page 45.
Sir, till now, with great respect to your lordship.
Yes, just one minute.
Till now, I have no dispute. I am accepting everything. Where is the dispute?
That I am, you also please bear with. That is how, page 45, your lordship may kindly see.
Let me hear not
Yeah,
putting the case.
Answer.
Answer. That's the.
I'm sorry, I can understand.
That's the part of the advocacy. Why you are.
I'm sorry.
So, page 45, this is electronic cash ledger bills. Two ledgers, you know, cash ledger, rate ledger. In cash ledger, my lords will find, because I have paid 7,85,000.
86,000.
7,86,735 credit entry, where the same day I deposited and debited. I deposited money in my cash account and it is also debited towards payment of tax for the same day. That is what I. Next page, page 46. It's a credit ledger. Your lordship will find integrated tax. I have paid 14,20,670 and central tax 7,34,373. Apart from that, I have also paid in the next page, because that is at page 47. Your lordship will find 10% when I find appeal millions, tax I had to pay millions 10%. So together millions, I have paid the entire amount of 32 lakhs. That is what I meant to submit to for lordship, and that is accepted position fact. Now what they say, this integrated tax millions out of 15 lakhs 20 millions, the 1 lakh 30 some odd, 36,000 some odd. They say that you should have paid from cash ledger. You cannot pay from millions credit ledger. My humble submission before your lordship is millions. Section 75, which is with regard to millers discharging liability under RCM, reverse charge mechanism, in cash ledger, in cash mode, millers. Rule 85.4. That's the provision, millers, which mandates that RCM liability is to be millers paid through cash miller. And the definition of output tax under section 281 excludes 282 excludes this RCM, reverse charge tax millers. Now the question is, millers, as I said, reiterating your lordship, 128A is a non-obstructive provision. So what is non-obstructive provision? Your lordship must have come across the number. I have also a recent judgment of 2025. I do have with me. I will be your lordship notice. But many times non-obstructive are counted in two different ways. One is not to mention anything called any other act enforcement, and at times also provision contents like the one here with the lordship. Not to mention anything contained in this act. That is what our act here has in 128A. So that means whenever act says so, not to mention anything provision contained in this act. So this will have overriding provision over all other corresponding legislative provisions that are available in the statute itself. And 128A is a recent origin which is there, because it is meant legislature intended, it's a matter of litigation policy, do away with litigation, not to insist upon penalty and interest if the entire tax is paid. And what is the mode of discharging liability belongs? Once any demand is raised in DRC 07, that will start reflected in the electronic liability register belongs. And if as per 128(1) obligation, 128A obligation, what that requires me to pay the entire tax, the moment I pay the entire tax, whether from cash or from credit, because 128A, unlike other, doesn't put any restriction, I can pay from. And once payment is made either from cash ledger or electronic ledger, credit ledger bills, the electronic liability register, there will be a corresponding debit entry. To that extent, that will get reduced. Here, 128A mechanism is such a way designed, because as credit liability register shows how much, 86 lakhs. Because my liability is 32 lakhs, interest penalty is there, together is 86 lakhs. But as in normal course, if I would have paid the entire amount, then that will be debited and the entire amount will go. Or in appeal, if it is reduced in part, if I pay that amount, it will go. But here, because of 128A provision of waiver mirrors, if I pay the entire tax mirrors from any source, be it cash or credit measure, that is what I have done here, then the entire amount will go.
But the rule which is apropos to this provides some mechanism that how it has to be done. So if that being the position and the rule is incommensurate with the substantive provision of the act, then in that event one has to follow that particular subordinate legislation.
But here 164(2)
if you say that the rule offends the provision of the act, or it is repugnant to, or somehow is an excessive legislation, you can then we have to challenge the violence.
Because those are not the situations here. Here we
What are you saying?
Yes, your lordship is correct, but those are not the situations here. My lord, correct. I have example. But here is a case 128A says once any liability is there on account of demand raised.
128A says that if there was any order passed under section 73, the particular subsection,
But that not all periods.
not for all,
Certain-
I understand,
Yes.
particular subsection which is mentioned there,
Minus.
then within a time as may be prescribed,
Correct.
if you pay the entire tax amount, then in that event you will be entitled to waiver of the interest and the penalty. No difficulty. There is no ambiguity in the matter. It does not talk about how it is to be paid, how that is to be paid, nothing.
The rule is there. Rule is there. 164(2) minutes.
128A does not talk about how it is to be paid and in what manner it is.
Correct.
It simply paid, says payment of tax. That's all. Now the rule is framed. The rule says that how that would be paid.
164(2). Let us see.
176 which you refer to.
164(2) minutes. Rule 164(2) minutes.
Page 9 of the petition.
176 you have done.
Page
You
164.
quoted.
One is I have quoted minutes.
It starts from page 8. It's marked in bold.
So this it says that you have to file an application in an electronic form.
Yes.
That is the GST SPL2
Yes.
on a common portal,
Yes.
providing the details of the order along with the details of the payment made towards the tax demanded.
Provided that.
Then provided that the payment towards such tax demanded shall be made
Yes.
only by crediting the amount
Yes.
in the electronic liability register
Correct.
against the debit entry created by the said order.
Yes, minutes. So now there is a debit entry available against the demand minutes, and whatever amount I will pay, I will have to ensure that the electronic credit liability register, is credited. Once it is credited, my task is over. That I have done. I have done that. Admittedly, I have done that. And what they say in the so-called notice, they giving a go by to 128A, giving a go by to 164, 1 minutes, they say because 1,36,000 a part of IGST minutes. RCM. RCM is IGST. RCM pertaining into IGST bills. My friend is correct. RCM, that is IGST.
Because RCM IGST
that's what I'm saying.
cannot be credited from credit ledger.
That is what I am saying.
CM is another's liability you are discharging.
Correct, absolutely correct. It's a reverse charge mechanism.
Your credit.
Which
that is not your credit.
That is not my credit.
That is his credit.
Correct.
So you cannot.
You'll have to, then you'll have to put it in the cash.
Put the cash. But only here what has happened. That is not the case here.
Yeah. The authority has said you paid in cash.
Exactly. That for that reason the entire 128 days.
So now
my debt is over 25.
and clarification.
Period of payment and all.
Your lordship recently has decided one matter where there what has happened, the credit ledger in the portal was showing zero. Instead of the demand which was there in respect of which 128 was filed by the petitioner, they came your lordship, it was showing zero. Your lordship set aside permitting them to make payment. They agree. Here also, as an alternative argument, just please. I am giving the other. I have with the copy. But here alternatively, I say that I do not know whether I do fair or unfair before your lordship. Because despite of the fact that 128A and 164 provides the manner of payment only restricted to crediting the liability register grounds, here 136 is not the total amount. If your lordship permit me, 136 also will without prejudicial deposit. Because your lordship in the other case also said we are permitting.
No, that cannot be deposited. Your lordship, because that 128 provision given a specific date. Your lordship. So how?
I asked him a question that the period which was prescribed authority for payment.
Of any time it cannot be, because that is an amnesty scheme.
Whether those have expired, the period has expired.
Only March 3rd.
I asked this question very often.
My lordship, can see your lordship has permitted, because that is also after 31st March period, and it's not amnesty. Your lordship always take exception to the expression amnesty. This is not amnesty. If I pay, then that will be waiver because your lordship has permitted. My lordship,
No, for limited period.
No, limited.
For specific period within specific date.
There cannot be a specific period because statute itself provides for 70-20 and I am
your lordship provision has to be challenged.
We are also not outside that period. Statute is only confining to 17 to 20, 17, 18 to 19, 20, and I am for 73. And for 1,36,000, entire 32 lakhs will go. I have withdrawn appeal. Where do I stand? That is how your lordship have come to the rescue of the petition in that case, and here also. Even I have made in my second time. Even I want to
the clarification immediately after introduction of 128 days. CBIC has issued the clarification by way of notification that this RCM has to be deposited through cash.
That is not binding on.
That is the provision.
So
everywhere circular.
I believe
the circular has to be challenged.
That is a frequency.
Because we are guided by the circular. Where the demand is in respect of any amount of tax to be paid by the recipient under RCM.
Sorry, paragraph 14.
And that 128A order is also appealable.
Yes, sir. I have seen that also. Here, Mr. Mishra, I don't know how. Is that there? Your friend has considered that you are arguing here.
Paragraph, typically, yes, sir. Paragraph 10.1 and 10.2 and then the 11. If read together, it was not a conscious decision which we have taken.
Copy, sir. Copy.
That is, you were otherwise.
Very benevolent. He appears.
No,
let's see, in that case,
so was indisposed.
Your lordship, in that case, I think there is some mistake.
We are conscious.
Paragraph 10.1, 10.2, and then read paragraph 11. Both in 3 paragraphs. You will understand that what was playing in our mind.
Out of 32.67 lakh, only 1.36 lakh. RCM involvement, which I want to pay. We know I have paid not once a year. Yes, yes.
That is the whole problem. There was a concession by them. That if it is deposited within a time, no difficulty, will consider. That was considered.
Also. I don't think. In that case,
No, I was not there.
He
I was
never
not there.
there.
Additional spending.
He never concedes.
he is also fair at
Like
times.
that one.
I think today.
With great respect to you. I'm
This is a
Are you disputing what he's saying?
no, I'm disputing.
You are disputing.
No. But your lordship says
He says that you are always a fair, so you are disputing. No,
that part I'm not disputing, but your lordship has said that never conceded, so that with great respect. Your lordship, in this
Legal aspect.
your lordship, in this case, that paragraph 5, for that reason, I think the concession might be there. Because that reflected zero. Total was zero, lordship, and there was demand was reflected zero.
Yes.
And for that reason. In this case, no, in this case cannot be your lordship, may not be your lordship. No, I have already. Your lordship, why I am saying, why I am submitting. Okay, so your lordship, as your lordship, please. As your lordship, please.
Collected.
No, tax.
So state is run by interest and penalty. Are you insisting for that?
Not at all.
So
he has violated the provision.
That's a technical fault. Actually, he has, if somebody kindly visualize what is playing, if somebody can deposit the whole of the 32 lakhs, everything, then in the agreement for freeing 1,36,000, he will not expose himself liable for double the amount which he has already deposited.
Your lordship, that I can understand.
The marginal amounts is small. That's why my brother is saying that you think over it, have a consultation.
you require tax. That's all. You collect tax.
And also my
And that, now, see. So, qualified bill, he has withdrawn his appeal also.
Your lordship.
Had he pursued the appeal, entire thing would have come. If he pursued his appeal somewhere. Was
Your
there
lordship, what my respectful submission, my Lawrence senior also, request my Lawrence senior.
Various situations that he would succeed somewhere.
He would have considered.
My Lawrence, I request my Lawrence senior also that at page 61, sir, I am requesting you at page 61, please look into that OGST you have deposited 7,87,000. Please try to convert it, that part IGST and remaining part OGST, so that it can be solved.
That is not here, sir.
Let him file an application. Let him. But it is only in the court because we cannot do anything. Because only as per rule, only upon his request.
From the appeal, now he cannot revive the appeal also. You have accepted.
Remediless man.
Rules 164 says.
Then you will again till another.
During that period, he was in the writ petition. Because
the sooner the better, you get the tax revenue, that's all.
Yes.
Be pragmatic.
Take pragmatic.
Yeah,
just regard.
Have the pound of states, not.
Here, let's see, after After much argument, this pragmatic view from the honorable court, your lordship.
Method of that resume observation of this.
Changing the portion.
Revenue authority should not be so
Yes.
efficient.
Yes, call the next.
Next
week.
Item 29.
Yes.
Item 30. Item 31.
31 is regarding the non-constitutional. Sub-item is also related.
Item 32.
16th matter that appeal matter that appeal is dismissed for the want of pre-deposit. Right. He has filed an appeal. Appeal is dismissed for the want of pre-deposit. In that 16 they have
31.
That's
what fees.
Yes.
Item number 33.
74.
Yes.
Item number 34.
Tax revision is filed against the tax revision is filed against the tribunal's order. Before I come to the questions of law, because at page 10 in the lordship's brief notes. Page 10. First question allowed is whether the tribunal is justified in holding the furnishing of declaration in Form C in respect of interstate sales of iron and steel goods was mandatory for the period 2002-3 as per the amendment of Section 85 of the CST Act by ignoring the notification dated 6th April 1991, notification dated 16th of September 1994, and notification dated 13th of October 2003 of the state government. The second question will order is whether the tribunal is correct in restoring levy of tax at the rate of 8% in respect of interstate sale of iron and steel goods in absence of declaration in Form C, particularly when condition number 3 of the notification dated 6th April 1991 regarding submission of declaration in Form C was deleted by the state government in public interest. But
if there is an interstate sale, then you have to submit.
no, there's an
intrastate sale.
the genesis. No, the genesis. Finally, come to Annex 4 at page 23. There's a notification dated 16th of April 1991. And this was specifically made for iron and steel. Now, if I may place that notification, in exercise the powers conferred under Clause B of subsection 5 of Section 8 of the Central Sales Tax Act 1956, the state government being satisfied that it is necessary so to do in the public interest, do hereby direct that no tax under the said act shall be payable by any dealer having his place of business in the state of Orissa in respect of sales effected by him to registered dealers in other states in course of interstate trade or commerce from such place of his business of iron and steel as specified in clause 4 of section 14 of the said act, subject to the following conditions. I'm concerned with condition number 3. There the condition was the dealer effecting sales in course of interstate sale of commerce also furnishes declaration in Form C and or D, as the case may be, as prescribed under the Central Sales Tax Registration and Turnover Rules 1957 to the assessing authority. The lordship need not come to court. Then if the lordship would turn over the page, this is a notification dated 16th of September 1994.
No, what it says is that you may not be able to give it, but you have to give a Form C or Form D.
That was a notification 1991. Then your lordship had turned over the page, my lord. Then another notification came dated
Condition was
deleted.
that condition.
Condition was
Condition
deleted.
number 3 is deleted.
Deleted. So my lords,
Then
from
everything
19,
was restored.
it was restored with effect from, my lords, 13th of October 2003, that's Annexure
The
6.
same condition was
Restored.
in 2003.
3, my lords. My
This
period,
subsequent year is
2 and 3, 2002, 3.
2-3.
So
So
this,
that doesn't come within this
True, man.
condition. That
Man.
is the question.
my lords. So what the learned,
So according to you, when there was no imposition or reintroduction of that particular clause 3, so that period was definitely governed by this particular notification of 94, and therefore
no necessity of a filing of a C forms. So what the tribunal did, my lord, is if your lordship would kindly come to section 8.5, my lords, as the relevant provision. 8.5 underwent a amendment of 11th of May 2002. In that amendment, they said that a C form was necessary, but the condition is that the state government has to come up with appropriate notifications. If your lordship would kindly come to section
8,
my lord, section 8.5.
yes.
Notwithstanding anything contained in this section, the state government may, on the fulfillment of the requirements laid down in subsection 4 of section by the dealer, this was introduced with effect. If you would see the footnote 2, this was introduced with effect from 11th of May 2002. If it is satisfied that it is necessary to do so in public interest by notification in the official gazette and subject to such conditions as may be specified direct. So and so, so and so, so and so. So my humble contention, my lord, is requirement of a notification by the state government in public interest was a necessity
in order to
comply with this.
8.5.
My lords, the learned tribunal, what they did, my lords, they said that since the notification, this amendment came with effect from 11/5/2002, even though the notification is 1 year later, it will relate back to that particular.
Introduction of the condition.
It says that it will have a retrospective operation.
My lords, which
So the past transaction would be remain open and
alive. But unfortunately, my lord, neither this notification gives retrospectivity, my lords.
No, in the cases, because that 1994 to 2003 is a long gap.
My lords.
It's a long gap. It's not a small time. That within 6 months or a year it has been cut. It has. Now there may be many assessments in the meantime, where the insistence to submit the Form C was not there, and that has been done in view of that notification.
So my humble submission is, my lord, neither the.
Since you come at the mischief of proximity, the close proximity of the time.
My period ends in March.
Everything has changed.
So my period ends in March. This notification came in October. So my humble contention, my lord, is that till such notification comes into play, this earlier notification of September 1994 still held the field. So that was effaced by coming to this notification on 13th of October 2003.
When the state government is conferred with certain powers, unless they invoke that.
So
this act, the provision in the act will not retroactively.
So that is my humble submission. And fortunately, the first appellate authority.
It has given affidavit saying that from 1994 to your case, they have always insisted for the Form C.
No, I've framed a question of law. Your lordship may call for that.
Can you give an affidavit to that effect?
And
you have always insisted for Form C after 1994 until.
Because that section 4.
No, I understand. You'll have to give whether you insisted in all such cases after 1994.
8.4.
Your lordship,
8.4.
That
Can you give an affidavit, sir? Give an affidavit that you have always insisted for Form C. We will It will not have consequences. No difference.
Respect of particular commodity.
It was not done in
transaction.
It was not
Nature of
done.
transaction.
It was not done in respect
You
of.
have in 1994 took a conscious decision and competent authority, competent department.
And limited to iron and steel, not all the declarations.
I know it's. And you consider what question I put to him. And look at his.
I can only repeat my learned senior, Mr. Sou's thing. He's always fair.
Mr. Karan,
I'm also always fair. I'm your student. I'm always fair to you.
Mr. Karan is now reminded of 2012 and 13.
How can he give it?
When Mr. Fati was arrested.
The tribunal order is also, so let's with great respect.
The appeal is definitive on the following substantive provision of law.
My favor.
No, can be set aside here.
No, let's.
Just take.
We can dispose of the appeal.
No, let's see. I'm just submitting my humble submission.
Understand that is means that we.
But all these details.
True.
Only
And
that.
yet he has
I don't want
retrospective operation.
Perhaps my learned friend wanted to say that it was an ex parte order. There was no appeal.
But not all these angles has been decided.
No, unfortunately, not.
Spare me.
Whether the
stupid also. He's appearing in this case. This interim order should be till disposal.
Didn't get.
Otherwise,
What opportunity has to be given to him?
he's not ex parte. So to Article
No,
226
it's
will not
expert.
operate in
It's
this
not an
case.
expert team, but still he has the right to file.
If he can,
Oppose the interim order.
if he can,
He has no say for admission, but he has the right to oppose the interim.
Because bona fide,
it's
original
consequential.
demand was there.
It's consequential.
Recomputation is just a formality.
They
Your
come and
Lordship.
ask for equivalence or the.
Recomputation is just a. Your Lordship, why I'm saying. No, Lordship, Your Lordship,
It's a reversing order.
Your Lordship, why I'm saying originally assessment there was demand.
It's a reversing order, Lord. I say it's a
It
reversing
has
order.
been reversed. Second appeal still it has been reversed. The same demand, my.
Come, for your benefit. Yeah.
Item 35.
Come.
And here's the last officer directed that inquire into the matter and that they have stated that it is operating in unauthorized site, the ward number 43 was given 42 as sanction site. And route 52A also.
Your contention that they are operating beyond the.
Yes, and the report has come that it is violated. They have beyond the.
Yes, the explanation is not that previously an inquiry was conducted. It was found the shop is operating on a site, not on the approved site. And thereafter, a show of notice was given to opposite party number 5. When a hearing date was fixed to 27th of November. On that date, a petition is also annexed. They have filed a petition because this present petition is pending on the self-same issue. The authorities may not proceed. That petition was filed by.
So we are discussing.
Yes, ma'am. So that's what.
So that it will not be, and we are fixing a date here.
Only because of that, Muller,
If they wanted to play, then we know how to cover it.
So we have conducted the hearing, only an order is to be passed. So my lord.
They're taking time. Think that it is pending.
Sir, that is very
Yes,
this is a very unique feature.
Yeah.
That without disclosing the fact, they wanted an adjournment because of this petition.
Yes.
17th/11.
We are passing off, taking observation in an omnibus manner. That mere pendency of the writ petition should not deter the authorities in proceeding with the matter unless there is a specific order of stay.
Matter is hard, only order to be passed. Because of this,
So that it will be circulated to all the departments.
On 17th/11, my lord, an shifting application has been filed with statutory fees.
Sir, you operated from an unapproved or unsanctioned site.
My lord,
If you have operated, then why?
after inquiry, my lord, immediately I
How can
filed.
you do as per your own whims and with the parent, whatever, the convenience you will do it?
No, my lord, not for my convenience, my lord.
That's the way.
Land particulars has to be verified by the authority. Whatever.
Sir, you were operating from an unapproved site. How can you operate that?
That's true, man.
So
in the meantime, I have applied for shifting that process.
what shifting? From an illegal or unapproved site to an approved site?
New site.
Or it should be an approved site to an approved site? Yes.
That is under consideration.
You are seeking a shifting of the shop. No. The instant repetition is at the behest of the
Lordship's request for adjournment, the leading counsel is Anko Station. Request for adjournment, argument counsel is Anko Station.
We are within the station.
So argument counsel is Anko Station.
That's a greater opportunity for the juniors to open up the case.
They are not external.
What? Start. At least you should know the facts.
Yes, sir.
Facts must be known to the junior.
Yes, I'm on the back.
So,
Next week.
what next week? Who is for the receipt?
You.
What is this matter?
First appeal order has been challenged, Your Lordship. Non-constitution of the GST tribunal, first appeal order has been
We are
challenged.
disposing of this matter.
Originally, Your Lordship.
Maybe limitation what?
Your
I
Lordship.
understand.
You're right, he has not deposited as per that amnesty scheme 12.5%.
Whatever.
Sir, for condemnation of
Deposit 10% and we'll go for appeal.
You're right, for condemnation of appeal.
We're disposing of the matter.
It's kindly claim that some submissions been made by senior, so kindly come to.
Nothing. This is what is there.
I get-
You will get an opportunity. Just you have to deposit 10%. Take an opportunity of going there. Is senior. When he is coming, expected to come in the station. You say out of station. When we can expect him in the station?
Next week. Next week.
Next week has 5 days.
Sir, by 10th. 10th.
You will be here.
Yes, sir.
10th as a first one. 1 minute back. 10th. Yes, first man.
Item 37.
Come with the order with the necessary correction.
37.
This, even though, my lord, my humble submission was in this matter, and I came to know of this order, my lord, after the attachments I've made. The facts of the case, my lord, is that my registration under the GST.
The connected case is also the same.
All the same. The 37, there has two writ applications. 37, item number 37 has two writ applications.
So that's why I'm saying.
It's the same, Lord, different periods.
Different period.
So what has happened in this?
Communication was not done.
No, there's no communication because of the fact that I was not.
It's not uploaded on the portal.
No, my lord, because I was not a dealer. What they did, my lord, is they have uploaded it in a VAT register. Email ID in the VAT under the VAT Act. So my lord, I was not privy to that because I was neither a registered dealer. The VAT Act is over. So that does not give me an opportunity to go back to the VAT email, my lord. My registration.
But you are getting an email in your inbox.
No, my lord.
You're not getting an email in your inbox.
My VAT email has a different term.
Has no inbox.
VAT is
portal has no inbox.
my learned friend corrects me. VAT has no inbox.
Email address which you have given.
No, VAT. So far as VAT is concerned, I'm instructed, my lord, that it doesn't have an inbox.
You have every dealer has its own address, email address.
Because
so this is communicated at your email address. I am
under the VAT Act, Lord. I had given the email under the VAT Act.
That email is active or inactive.
It is inactive. It is inactive. My registration under the my lord, and that registration certificate of
We are never registered under the GST.
we are not registered because my registration was cancelled with effect from the lord 2nd of September.
Yeah. 2nd of July.
July, no. 2nd of July, it was cancelled. Of 2017. So I'm not a registered dealer under the GST Act also. So thereafter, my lord, this order comes to my knowledge, my lord, when my banks are attached. After that, I made a query, my lord, and I come to know of this order, my lord. So when I come to know of this order, my lord, I
received the money which you have executed the work prior to introduction of GST.
Yes, sir.
Post GST, you have received the money.
Yes, ma'am.
So on that basis, they have proceeded to assess unregistered dealer or treating you unregistered taxpayer.
and uploaded So under section 67 and uploaded it in my VAT email.
They have not given you the physical copy or by
No,
post or
no,
something?
no, my learned friend.
Yes.
Take instruction, they're not given.
If there was no email details, nothing.
No opportunity.
He
And
does
no
not have an
opportunity of
access
hearing
to a
also.
GST portal.
Even he is not registered.
He is not a registered.
So he should have shown this turnover in the VAT returns. That is why you have given him the final cost and not registered after he has to pay him.
All that will
No, your lordship, it is like 18-19, not 17-18. 18-19, 19-20 period, your lordship.
So he is not a registered GST.
Your lordship, register what happened? Migration, all the dealers whoever in the VAT, your lordship, they are migrated.
I have not.
Your lordship,
Automatic.
your lordship, automatic migrated, their number, temporary number has been allotted. They have given that number to their contracting. Subsequently, within 3 months, they have filed a part form 2 in order to complete the migration. They have not filed the part 2, but that registration has been cancelled. That cancelled.
Then they become unregistered.
Your lordship.
So
unregistered assessment proceeding
will
has
you not, if you initiate a proceeding,
that order
whether they are entitled to a notice.
Your lordship.
Perhaps
Notice has been
what's the mode of
uploaded.
notice?
Notice has been uploaded.
Now I'm saying that they are taking advantage of our judgment as well. That once we uploaded on the portal, it is a sufficient compliance.
Your lordship,
He is non-registered.
I have considered something. So far as the 63 is
How
concerned.
many access?
No, lordship. So far as the 63 is concerned, because of your lordship's interference. Your lordship, I have instructed to the department.
But it is not. It is a special fact.
Page 43 of the
Shown in the VAT returns.
Let him show. Here, your lordship, let him show a VAT return by showing this much of amount.
Let me go back, the lottery will kindly turn to page 43.
But they have just posted on the portal. When the access to the portal is not given them.
The lottery will kindly see page 43. My registration stands cancelled, page 43. It's effective 1/7/2017. The date when the GST Act came into force. Page 43, a lottery may kindly see. You were registered under the GST bearing number so and so for the month of so and so. Date of cancellation is 1/7/2017 and thereby becomes unregistered payer with effect from 2/7/2017.
So what temporary number? If he is not a registered, then this notice at the portal, if he cannot have an access to the portals, why he will go? He is not a registered one. So in that event, you will not give him a notice by post and to his address.
In fact, your lordship, long before we have realized that, and we have issued the instruction to all officers of the state that so far as the 63 assessment proceedings are concerned, the copies are to be served to the bill. Physical copies.
All that is praying, Lord. This is just one more opportunity, Lord. That's all I'm praying. One more opportunity.
You have to, on the ground of violation of the principle of justice, and then go, let them contest. If you found that they are evaded, impose whatever. But given the opportunity.
But this is the peculiar circumstances here, let's say. So, by from the very beginning, your lordship might have remembered my lord and senior was arguing this case while started the argument. I have considered. Your lordship, from the very beginning, your lordship might have remembered. Because 63, I have realized, your lordship.
Yes. Both the periods.
Both the periods. 17-18 and 18-19.
Now you have a notice.
Pardon?
Now you have a notice.
Yes. Yes. That is.
I have a notice. Your lordship.
Now your lordship
at least
4
weeks time, Lord, to collate all those papers. I'll appeal, Lord. After 4 weeks.
Contesting, have you not without collating the papers?
Further.
No further.
I can't appear immediately, Lord.
No, we'll say that. You will appear on a particular
Your lordships are gracious enough, Lord, to
particularly fix a date.
Your lordship.
So that
your lordship. Your lordship.
At least
also your lordship. Also your lordship.
Outer limit.
Outer limit. Your lordship.
4 weeks or the after, my lord? You're not.
3 weeks.
Oh, 1 more week, my lord.
No.
My lord, at least let my learned friend, my lord, enjoy his Christmas.
Sometimes the bench should.
Your lordship,
That's the same.
first week of January, my lord. Your lordship
No,
always has
3
3
weeks.
weeks. No, let him enjoy his Christmas, my lord. It is
No,
1
let
week.
them.
1 week Christmas, my lord. Thereafter, 1 more week.
No. The name does not suggest. Yes.
Ask it.
Yes. What he has to do with the Christmas?
No, learned friend, my lord. No, the festivity, my lord, the festivity is pan-India, my lord. Maybe the religious fervor, my lord, and all that, my lord, may be confined to a particular community. But the festivity, my lord.
The enjoyment in the Christmas,
Oh,
the
that's the-
manner in which it is enjoyed, let it down.
So far as Orissa is concerned, this is the best time, my lord, to go out. No other. It becomes hot after January, my lord. Except that.
Yes.
I don't need-
Within
1 more week. 1 more week.
No. Yes. Next.
Madam, item 38.
Fix the date.
Okay.
Fix the date. We haven't now communicate to him the date. 3 weeks will take us to what?
24th December. 24th December.
Yes, by 24th December.
You fix another date. I'll appear on 24th.
3 months in complete.
No,
24th December is the date. You just go and appear before it, whatever.
No, let him fix another date. But otherwise, you'll say that produce. No?
It will complete within 3 months. 3 months.
Much of it.
Yes.
38.
No, 38, I'm appearing on behalf of Mr. Ganesh Mahanti in this particular matter. There is certain medical emergency.
But this matter already.
How much have you?
Already is.
Yes. Yes.
Which is granted. If 2 weeks time will be.
No. We have almost completed
Yes,
the declaring. So further, because his name is not reflected today.
Yes, ma'am.
Here, Mr. Karthik Kurmi is.
Yes, he's appearing in that particular
So
matter.
next week, yes.
No, may I just pray one thing? If we are permitted to file a written note by the next week, sir?
No return note. Not.
You have already filed.
No, my lord, only writ petitions we have filed. If we permitted.
Not required. You already document with you. You have already filed it. Don't improve the.
No, so.
Next week.
Yes, sir. On 11th. it will be. Item note 13.
Look,
It's fine.
lots of.
Item 39. 11th.
Great. Great.
39.
Yes, well, I found out something interesting with my lord last time asked me to bring some ammunition. Actually, on that Glaxo, I've given him a 3-page written note. That's not much. In fact, Dr. Simbi also, my lord, has given one 23-page note today.
123 page.
23 minutes. My note is only for 3-page notes.
There's not a secret document.
But what I am suggesting, now that Mr. Singhi is assisting or assisting us with the Surya, and he has given a note below, let the note be shared among us below, so that we have an occasion to see us. And after going through the note below, we have also prepared one compilation. To submit it.
Sahu, is that to be recorded as original or no?
He is assisting the court. We need that. His opinion is also very valuable for the court. So your opinion is equally valuable.
No, your
So
lordship,
we'll consider that.
open mind, your lordship have invited all the members of the bar rather.
Yes.
So at least your lordship.
No.
Should we record that it should be?
No, what I have requested, my lords, that the note which has been given, let it be with us also, we will go through.
You have your opinion, independent opinion.
No, if your lordships will see, in fact, the Glaxo was the first of its kind. I found out.
We have certain reservation because annually that which was this has almost come to say that in the lines of your that has been taken care of in Glaxo. That's
If your lordships will see, the Glaxo, which actually the paragraph 19, which the department is actually trying to lay reliance on that. The para 19, the court has observed that since the ONGC a 3-judge bench judgment, we are 2-judge bench judgment, therefore we have to follow the ONGC. But in the background, the ONGC law is a statutory appeal. The Supreme Court was exercising section 125 limitation.
See, Justice Sugandhi has recorded and observed that 226 power can be exercised in such matters. Perhaps following Salem, but still that judgment has taken to a Glaxo.
Okay. I'll look into that a lot. I only been saying that so far as the maintain, because the other side is actually raising the maintainability. Now, maintainability can never be the question.
No.
Yes.
It is also misunderstood. Our observation was misunderstood in that sense. We are quite conscious and quite alive of the proposition of law that there is a vast distinction between a maintainability and entertainability.
And entertainability.
If the proceeding may be maintained, but may not be entertained.
Entertainment.
Correct. Now, what I find that the observation which came from that judgment is that it creates a complete fetter on the entertainability. It's an absolute fetter or creating an absolute bar in entertaining. Entertainability, as we perceive, is really a discretionary and depends upon the facts of the case to a case. In some cases, the court can entertain. In some cases, may relegate the parties to exhaust the statutory forum. But once the language creates a complete bar in this particular situation, that the court shall not entertain under any circumstances, that is where we wanted you to assist the court whether there can be any absolute fetter to be put.
That
in
is
entertaining. That
is already settled.
Dr. Singhi has gone, but he has also, I think, the union has not.
What he has observed.
He has not said. Actually, he is on the. He is of the view that the bench wanted that it is not maintainable. I never said it is. Maintainability is always in favor of Article 226. It's a basic structure.
There is no question on
it. There cannot be any fetter. I am conscious of Elchandra judgment also.
Absolutely.
There is no fetter.
Then in that case,
entertainment.
Yes, in the entertainability on the issue of the delay, it is always justiciable. Now, because the forum is not there after 4 months in the GST Act, Section 107, therefore I come to this court seeking your lordship's indulgence to not the adjudicate whether whether our lordships will exercise the discretion, which is a subject of policy and subject of discretion and the convenience. These principles as a rule under 220 is laid down by this on the court time and again, that whether this particular delay committed by me coming before the court beyond the statutory timeline law, whether it is condonable or not, whether I acted in a bona fide manner or not, whether there is, so therefore, so far as the Para number 2.1.
Yes.
Well, what the interesting, lots of space, see the paragraph number 2.1 of my written note. What the Glaxo's observation, I have put it in words in the bracket. That is actually the para 19 extract I have given. If you also will see in the background of this question number 1, the para number 1, where the questions was framed, then the para number 14, 15, right up to 19, and then Malod, you'll also see the 23 paragraph. That is where Malod, the Glaxo itself actually examining the delay. It is not in the sense intended to say that the court has no jurisdiction, because the very reliance of the ONGC, there was no subject matter discussion of a 226 or 227. It was a court, the Honorable Supreme Court was exercising statutory appeal under section 125, and the court said that I can't even give a condonation delay for 1 day, because that would amount to violating the provisions of 125. That's about the ONGC. That's why, let's read it for a moment, paragraph 19, that perhaps will be clear, and then the paragraph number 23, in the background of the questions framed at para 1. Here, what I have said, in the paragraph number 2.1, the observation, the Glaxo 2020's adverse observation. What are those ballots here? The logic applied in these cases, full bench decision of Andhra Pradesh High Court in Electronics Corporation of India, which had adopted view taken by the full bench of the Gujarat High Court in Panoli, and also the Karnataka High Court in Phoenix, proceeds on fallacious premise. Section 31, 2005 Act, that is the Andhra Pradesh VAT Act, cannot curtail the jurisdiction of the High Court. Under Article 226 and 227, it is not a matter of taking away the jurisdiction of the High Court. In a given case, important here, in a given case, the SSC may approach the High Court before statutory period of appeal expires to challenge the assessment order by way of a writ petition on ground that same is without jurisdiction or passed in excess of the jurisdiction by overstepping or crossing the limits of the jurisdiction, including flagrant disregard of the law and rules of the procedure, or in violation of the principle of natural justice, where no procedure is specified. High Court may accede such a challenge and can also non-suit the petitioner on the ground that alternative efficacious remedy is available and that be invoked by the writ petitioner. However, if important here, if the writ petitioner chooses to approach the High Court after expiry of the maximum limitation period of 60 days is prescribed under Section 31, High Court cannot disregard the statutory period for a redressal of the grievances and entertain the writ petition of such a party as a matter of course. Doing so would be in the teeth of the principle underlying the dictum of a 3-judge bench. Interesting here, of this court in the ONGC. In other words, the fact that the High Court has wide powers does not mean that it would issue a writ which may be inconsistent with the legislative intent regarding the dispensation explicitly prescribed under Section 31. That would render the legislative scheme and intentions behind stated provision odious. This is the paragraph number 19 I have extracted. In the background of the question number 1. That is at para 1. What is that question? Whether the High Court, in exercise of its jurisdiction under Article 226 of the Constitution, ought entertain a challenge to the assessment order on the sole ground that the statutory remedy of appeal against that order stood to the assessment order on the sole ground of
by the law of limitations.
Correct, laws. Here, the law of limitation, if it's the only sole ground, because the petitions, for example, I have brought in before my lord, is not on the ground of only the limitation, number 1. Number two, even on the limitation, you'll also see the paragraph number 23 for a moment. Just read it a little further. That besides, it has mitigated the paragraph at paragraph 23 to the extent of the following. What I have done is that paragraph number 23, I have broken down to ABC. Facts noted in the first part of the para 23 was no bearing on justification of non-filing of the appeal within the statutory period. The respondent had relied on the affidavit of the sole site director and no affidavit of the employee concerned, so and so, or at least the other employee who was associated with the erring employee during the relevant period has been filed in support of the stand taken in the application for continuous delay. No finding has been recorded in the High Court that it was the case of the principle of natural justice, violation or non-compliance of the statutory requirements in any manner. Be that as it may, since the statutory period specified for filing the appeal had all expired long back in August 2017, which is about 1.5 years itself, and the appeal came to be filed by the respondent only on 24th of September 2018, without substantiating the plea about inability to file the said appeal within the prescribed time, no indulgence could be shown to the respondent at all. Now, Glaxo 2020 involves the following facts and circumstances with the following observation, both in the favor as well as against the writ petitioner in that case. On one hand, it records and observes the following in support of the writ petitioner, that is, as regards the High Court's power to issue directions, orders, writs in exercise of its jurisdiction under 226, same is no more res integra, referring to the other paper mills, wherein it is observed that where a right or a liability is created by a statute, wherein which gives a special remedy for enforcing it, the remedy provided by that statute must only be availed of. That reason can have no bearing on the justification for non-filing the appeal within the statutory period. Pertinently, no finding has been recorded at the High Court that it was the case of the principle of natural justice violation or non-compliance of the statutory requirements in any manner. Be that as it may, since the statutory period specified for filing the appeal had expired long back in August 2017 itself, and the appeal came to be filed by a respondent in 24th September 2018 without substantiating the plea, so and so, that I've already read it. Then, on the other hand, it records some adverse observation at para 19 against the writ petitioner as noted in para 2.1, which I've read it. Now, what I submit that the paragraph number 2.3, the Glaxo 2020 at para 19 wholly relied on the ONGC 2017, which is a 3-judge bench judgment, which was rendered by the Supreme Court as a statutory appellate authority under Section 125 Electricity Act, where Article 226 and 227 was never an issue. And so, observation at para 19 to the effect that doing so would be in the teeth of the principle underlying the dictum of the 3-judge bench of this court in ONGC is explainable on the facts of the case in the context of the Article 226. A concept of ratio decidendi, the vital dicta, stare decisis and precedent, which I've given a table of judgments, mostly for foreign concept, pales in the front of Constitution of India. Above proposition would not impinge the judicial discipline and judicial hierarchy and judicial finality concept.
There are many doctrines which you will not find any place in the statute book.
Correct.
But have been embraced through a judicial via. The principles originating from a common law principles, those have also been ingrained into our Indian legal systems. Many principles that you cannot. So this is what sometimes once we accepted this, I think that even contains the character of a law in that sense. You are talking about stare decisis principles. You are talking about the obiter dicta. There are many maxims which we have accepted. The actus curiae, we have accepted that maxim into the legal system, though there is nothing which can come. So all these principles are first very form. These are the legal maxims which we have engraved, though there is no legal frame. So this becomes a part of the law.
Well, may I?
But say this is a foreign origin,
I'll tell you.
it should not be given credence in the legal.
My intention was not that. May I just explain now? I have found out, if I may share with your lordships, may see all those jurisprudence of the doctrines, which is pre-1950. I have found out from my own research, I can share with that with your lordships. Your lordship will say the traces, your lordship will see the traces of those doctrines in almost many statutes in bits and pieces. They are already there. Yes. No.
Put through the legislative law, through an executive instruction, or through a judicial pronouncement, in entertaining the recommendation, when the High Court is provided the power, even the exercise,
Judicial review,
which is more than the power under Article 32. Can it be squeezed into a particular shell? It should remain open. And the facts of a case must be tried and applied. That is what troubles us. Now I'm making it more with clarity. That troubles us. That interchangeability, can it be abridged? Can it be close?
It's a lies.
It's a statute that over into others.
Habeas corpus, yes. These are plenary constitutional powers and functions. I ask, you'll also be seen in another technical angle. Can the 246, where the law is made by the parliament as another institution, a constitutional institution, can 246 will impinge into 226? 32, answer is no. Even the parliament cannot invoke the 368 also. That's why the basic structure.
That is what it was there.
Correct. So therefore, no, what my lord has done right up to, my lords, even 2023, my lord, I can show your lordships one, a triple, the three judgment of the Honorable Supreme Court, even that, my lord, your Godrej, where the entertainability and maintainability, they are saying when there is an alternative remedy, this court's power can never be. Only thing it's saying, repeatedly saying, my lord, it's a settled law. Actually, there is no debate on this. That the court will exercise a discretion, convenience, and policy as to the particular facts and circumstances, a particular relief can be granted or not. Whether somebody, for example, I'm not seeking enforcement of the 85 or section 107. What it's saying, the restriction, my lord, is where the statutory authority exercising within the perimeter of the statute. Now that can never, I found it very interesting, my lord, barring that paragraph 19, which I have explained to this extent, that actually the court was little lamenting that can we breach the three-judge bench judgment of 2017 ONGC. But perhaps, my lord, nobody could brought to the kind notice of that court in that proceeding that it is actually not with respect to the Supreme Court exercising power under the 226-32 or for that matter, my lord, 142. It was a statutory authority, not exercising the function as a Supreme Court. In the sense that we all know, my lord, it's the constitutional court. That's exactly what the ONGC said. I would like your lordships to read the ONGC for a moment to understand. The court is saying that no, even one day I cannot condone it. Whereas the entire context and what the discussion that happened, my lord, in that ONGC, when the statutory appeal could not have been breached because the court is saying I cannot because I am exercising statutory power function, the party.
You are arguing that this particular three-judge bench in ONGC has been wrongly constituted and borrowed in the Black Supreme. But once the Supreme Court has accepted a particular proposition which is laid down in an earlier judgment and applied in a particular given situation, can the High Court go and say that this particular application of the ratio in that judgment is misplaced?
No, my lord. Your lordship need not have to. Yes.
We are bound by the situation which is from Article 141. We have accepted that we can't take a departure therefore we have to follow that.
Yes.
The problem is that
I have three judgments to show.
that is what I say, that there is one line where one can think about, or the High Court can think, that it was subsequent to judge bench did not notice the earlier two judge bench. One, then the High Court will definitely will in dilemma which judgment has to be followed. Then the Supreme Court prosecution bench has a clear answer in this regard.
My lords, yes.
No problem. So there is no difficulty on the part of the High Court to apply those principles of law. Or there was another larger court judgment which was unnoticed. We know that principles of the pari curiam will also come. We can definitely.
May I give you a mathematical presentation?
This is what I really wanted.
It may answer this question. May I, my lord, endeavor to give a lots of kind of a graphical sense to answer this question. For example, in a particular given matter, a case, a ground was adverted to and adjudicated on A, B, C, D. And in another matter, whether it is the High Court or any other forum law, it is competent to adjudicate. Now, a party concerned goes to that the Honorable Court and says that the judgment of the Honorable Supreme Court is on A, B, C, D. I am giving you E, F, G, H because that E, F, G, H is yet to be adjudicated, which has a bearing on the final outcome of my matter. I am not commenting or lamenting on the judgment of the Supreme Court. That's what we call it as a factor substance.
It's a factual matrix.
Yeah.
If it is decided on that score, no difficulty.
That's what I mean. That's his case.
So we don't have to, because there are series of judgments on a statutory interpretation where the ratio has to be cut out from the context in which it is so used, and it cannot be used in an abstract or an abstract manner.
Correct.
It cannot be done. We are conscious of that, but when some observations have impacted upon the interchangeability, that is what we are more concerned, because who is the ultimate affected?
Well, the ultimate affected party also, in a sense, well, if I may say so, the court today, post 2005.
Lords. Fix 1 day for this.
Yes, my lords, it has to be fixed so that at least it can be solved.
This one also, certain judgments are being passed.
I have also compiled the some judgments in the means.
So that's
I have also compiled.
I have
compiled a list of
extracts.
Compiled a list of all High Court judgments which have followed the Glaxo. I've also compiled a list of all High Court judgments which have followed Glaxo. So far, I have not found a single High Court which has not followed Glaxo. 15 High Courts have followed Glaxo, my lords, consistently. There is no dispute about that.
Our honorable,
our High Court, my lords, in Vikas Mani, lordships bench.
That judgment and
one more better.
Lordship, in fact, the Lordship wants to entertain, then it has to be repertoire adjournment.
In fact, my lordship,
your lordship and coordinate.
43. That it was not noticed in that sense. There's no difference.
No.
That
should be taken up the top of the any day, your lordship.
Item 43 not. Situation is more. This matter is more.
Lords, in fact, the principle in Glaxo, my lords, is not anything new. 1960.
1 minute. Look, can it be?
Now, let them show their bona fide.
Given